you already know. Turn it up, lean back, feel the breeze. Late night truths drifting through the trees. It's for the culture, by the culture. Brainley's got the soul to show ya. Breaking it down, lifting it higher. Feel the rhythm, spark the fire. Headlines flip with a soulful twist. Behind the scenes where the magic sits. It's the heartbeat of the now and the then, where the story starts and never ends. Tune in, lean and feel the groove. Every moment, a vibe you can't lose. It's for the culture, by the culture. Brainley's got the soul to show ya. Breaking it down, lifting it higher. Feel the rhythm, spark the fire.
Well, hello to you, and you. Welcome into another edition of Brantley's Virtual Tour Live. We are live on tour on this Friday night, the 26th of December, 2025. Y'all, next week we'll be into a brand new year, new destinations. Child, what will we cover in the new year? Only God knows, okay? But as of right in this space right here, right now, rather, we're going to talk about Milagro Gramz, because there has been a motion to reinstate the defamation. That's right. You remember how it was $75,000, but then it got dropped down to $59,000. Then there was the whole thing of, because Milagro is supposedly new media, said no one ever though, that she was supposed to get a, cease and desist and all that stuff. So let's get into it. Higher is waiting, low is available, but either way, we gotta go on tour. Yes, indeed, we do. Let me take down this iconic intro here. You see that virtual tour background? Yes, you do. You hear that virtual tour music? Yes, you do. And then there is me. Hey, everybody, welcome in. Yes, I got my hair cut. Shout out to my dad. Love my dad. One of the greatest dads I've ever had. Also, my bio dad in Little Rock, Arkansas. Shout out to the 15 people here. Thank you so much. And by the way, y'all, tonight at 8:30, I want y'all to be here because we are going to do something brand new. Okay, I know what you're thinking. Brand new? Brand new? Yes, that brand new. So here it is here. Right here. Brantley's virtual tour jumper crawl. I cannot tell you how it's going to go down, but believe me, you definitely going to want to be here for it. So with that being said, here we go. Here it is. Shout out to Document Tings on Twitter. Okay. So this was entered in the docket on December 23rd, 2025. Megan Pete, the plaintiff versus Milagro Elizabeth Cooper, defendant. Plaintiff's motion to reinstate jury verdict as to defamation claim and to amend final judgment or renew motion for judgment as a matter of law and incorporate memorandum of law. Right. So here we go. Plaintiff Megan Pete, plaintiff by and through her signed counsel and pursuant to federal rules of civil procedure 50B, 59E, and 60B, respectfully moves this court to reinstate the jury verdict as to plaintiff's defamation claim and to amend the final judgment consistent with the jury verdict. In support, states as follows. This is the introduction, everybody. This case should have been tried. It was rightfully tried on the merits of plaintiff's defamation claim. At the pleading stage, the court properly decided a threshold and is positive status issue that defendant is not a media defendant entitled to protection under section 770.01. That ruling, which was not challenged by defendant, governed sequential proceedings. The parties proceeded through discovery and trial preparation in reliance on that ruling under the law of the case doctrine. That legal determination governed later stages of this case. absent a recognized exception. Despite the fact that defendant never moved for reconsideration of that ruling, never moved for summary judgment on the basis that she is immediate defendant entitled to pre-suit notice, never included this issue in the parties' joint pretrial stipulation, and never raised this issue at the October 30th, 2025 pretrial conference. Defendant led the court astray at the November 10th, 2025 final pretrial conference and during the trial, and rejected the defendant's status defense into the trial. The court ultimately allowed the inclusion of several special interrogatories in the verdict form concerning defendant's status as immediate defendant, including one specifically asking whether defendant was immediate defendant. The jury returned a verdict for plaintiff on defamation, but answered the interrogatory asking whether defendant was a immediate defendant in the affirmative. The court then entered the final judgment that did not include the jury's verdict as to plaintiff's defamation claim, because the jury's conclusion that defendant was an immediate defendant precluded judgment for plaintiff on the defamation per se claim. This outcome impermissibly allowed defendant a second bite at the apple on a settled legal issue. It should be corrected. This motion does not seek to relitigate matters already properly decided, nor to present new evidence. Instead, plaintiff asked the court to correct the legal error that directly affected the outcome of the case. In this case, the submission and use of an ultimate status question that the court had already decided as a matter of law. Relief under rules 50B, 59E, and 60B is warranted to correct this error and prevent manifest injustice. So basically, what this is saying here is that when they were doing discovery, right, and when they were setting up the plot of this trial, right, the main issue here at the pleading stage, the court decided a threshold and dispositive status issue that defendant is not immediate defendant entitled to protection under 770.01. So at the pleading stage, right, the court properly decided that threshold, that defendant is not immediate defendant entitled to protection, right? So because of that, they now want that to stand after the fact. Hello, Kayla, welcome in, and hello, Heather, welcome into you as well. So this is the thing, right? I believe that this could actually work, because at the beginning, middle, end of the day, as we all saw, right? Because we covered it. Let me go back to our channel here for a minute. Let me go back to our channel. Let me see here. Go back to our lives. Yeah, we streamed one day ago. Milagro Gramz going off about how she wasn't chosen to be on the list, this, that, and the third, And, you know, Milagro made a response saying, I never want to move to New York. Never want this, that, and the third. And of course, the mob radio, the cult that they are, agreed with their leader, but it was a backhanded compliment, right? So you were big mad that Armand was on the list, but yet you weren't on the list, and then you said that you didn't want to do it anymore, which media defendants don't have that type of energy in how they speak, right? They just don't. So it's like, do you want to be new media or do you not want to be new media? That's the question. And I do believe also too that they could have honed in on this more in the trial, but also too in the trial it was to the point of, did Milagro Cooper did what she did? Did Milagro Cooper do the crime that Megan Thee Stallion accused her of? And we found out that yes, of course, she was guilty. So yes, indeed. Let's get back to this here. Factual background, defendant exhibits nothing that immediate defendant would. She, one, is not objective, disinterested, or neutral reporter. Two, makes biased commentary intended to promote her business. Three, disclaims being a journalist and flouts its code of ethics as inapplicable to her. And four, disseminates false interrogatory messages that misinform the public. A, defendant is neither neutral nor disinterested. She is a biased representative of Mr. Daystar Peterson. Number one, defendant aligns with Mr. Peterson prior to his criminal trial. The evidence at trial and affirmed by the jury proves that defendant is not a disinterested before. Rather, she's a paid surrogate of the Peterson, Sunstar, and Daystar Peterson, hired to promote their false narrative that plaintiff lied about being mildly powed and further smear her reputation by branding her as an alcoholic, mentally retarded. I don't use that terminology, but because it's here in the document, we're going to go with that, ladies and gentlemen. Among other attacks, mere months after Mr. Daystar Peterson, plaintiff defendant wasted no time aligning herself with him. Speed trial exhibits J47 on defendant's September 17, 2020 Instagram direct message with Mr. Daystar Peterson. I don't know how you're doing your live tonight, but if you gave me that or any exclusive, it'll change my life. So that would be quid pro quo. You scratch my back, I scratch your back, right? So that's basically all that is there. J48 defendants September 2020 Instagram message with Mr. Sunstar Peterson, who requested to speak to her off the record. By aligning herself with the Peterson, defendant aided Mr. Peterson's circumvention of the protective and gag orders that prevented him from speaking to more about plaintiff in relation to the criminal case. Defendant willingly became Mr. Peterson's personal publicist and bullhorn, someone Mr. Peterson could rely on to publish his knowingly false and debunked narratives while maintaining consistent line of attack against plaintiff. Defendant performed her services not as an impartial reporter or journalist seeking truth, but as a paid surrogate, compensated by her purported sources to spread the company line, or to told the company line to anyone who would listen. See Milagro Cooper trial 178:19 to 179:12 on November 18th, acknowledging Sunstar paid her $3,000 over the course of 17 or so months. Trial exhibits J261 defendants October 30th, 2024 live stream bragging about being on Daystar's payroll and receiving birthday wishes from him. Now, see, here's the thing. Let's just say, right, that I had a contract with, Skull Candy headphones, right? And let's just say that for $5,000 a month, they want me to wear their headphones on Braden's Virtual Tour Live. That's what we call a retainer, right? So when you say you're on somebody's payroll, as an employee, right, you basically have to do what they say. And you did say that in your live stream. So there it is from that. J353 0312 468 defendants text with Sunstar discussing Houston meetup. J353.052-4 defendants text with Sunstar discussing Miami meetup. J353.087 defendants text with Sunstar discussing Los Angeles meetup. Sunstar Peterson deposition trial 5825-59-2 November 20th, 2025, acknowledging that he paid for defendant's flight, hotel, and general travel and business expenses when he visited Miami. Now, usually, when it comes to media, for example, and I remember this because there was a woman named Tiffany Cross. For those of you who may not remember Tiffany Cross, she was on MSNBC, now it's called MS Now. But she was on there with a show called The Cross Connection. And one of the things that they allege that Tiffany Cross did, now I don't know this to be true, okay? This is just from reporting. Let's just say that you had an assignment, right? Let's just say I worked for ABC News, or ABC rather, and they said, hey, Bray, we're going to fly you out to the Oscars. You're going to cover the Oscars red carpet live, right? When you are going to book for the trip, right, ABC will pay for the flight, they'll pay for the hotel, they'll pay for the transportation, they'll pay for the food, but up to a certain amount, right? So there are like approved hotels, but what ended up happening allegedly is that Tiffany Cross would stay at more expensive hotels and do things that were not within her per diem. her allowance, her budget, right, from MSNBC. So, but that's more of a media organization. But if you say you are a journalist, journalists usually don't get paid like that. Unless you are like a Barbara Walters, you know what I mean? Where Barbara Walters did these big interviews. And of course, Barbara Walters got paid, but she got paid from ABC News, right? She got paid from ABC. Nobody paid her personally to come interview them, right? So just want to get that context, conjecture, and connection. Number 2, defendant proudly showcases her allegiance to Mr. Peterson during his criminal trial. Leading up to Mr. Peterson's criminal trial, defendant and Mr. Peterson's father coordinated a public relations campaign designed to obstruct justice and attack plaintiff's credibility. Defendant's flurry of text with Mr. Sunstar Peterson reflects just that. See trial exhibits J353.071. Defendant's November 24th, 2022 text with Sunstar, who asked defendant to send him those materials ASAP before 2 attorneys. So journalists can't do that. I remember with Chris Cuomo, right? Chris Cuomo, who's been around for a very long time in media. He was on Good Morning America on ABC. Then he moved to 2020. Then he moved to CNN. He was a part of CNN New Day, which was, the flagship morning show. Then after that, he moved over to Cuomo Primetime, and he was one of the top slots on CNN. But then his brother Andrew Cuomo got into some SA allegations, this, that, and the third, and CNN found out that Chris Cuomo was helping out his brother Andrew, right? And you can't do that, right? So you have to be impartial and this, that, and the third. So because of that, he got fired from CNN. He asked the Chris Cuomo Project for a couple of months, and then he was hired at News Nation. So when it comes to like stuff like this, journalists are not supposed to intervene like that. Okay. J19, defendants November 25th, 2022 email with Sunstar with alleged dirt on plaintiff attachments that may be of value. So what this is giving me is the energy of campaign opposition research. How when you're running for president, you'll pay whoever to find research about your opponent. So there is that. Right here, J353.073, defendants December 2nd, 2022, Texas Sunstar for alleged dirt on plaintiff. J353.074, 5 defendants December 7th, 2022, text with Sunstar, who asked defendant to call him ASAP to discuss breaking news on a detective involved in today's Star case. Defendant scoured the universe and dug up every dirt, whether true or false, but that was not defendant's sole role. Peterson's knew that with every exclusive news, with every exclusive news they broke to defendant, she would take to social media to share it with the Bob defendants following. Trial exhibit J353.00077, defendants December 9th, 2022, text with Sunstar. Defendant attended every day of Mr. Peterson's criminal trial and sat with Mr. Peterson's family in the courtroom gallery, not with the media. Yeah. I think this has the makings of something. I really, really do. Because think about this. When the Diddy trial happened, right? There was nobody from the media sitting with Diddy's family. When it came to the Jonathan Majors case, nobody was sitting with Jonathan Majors' family. When it came to the R. Kelly case, nobody was sitting with R. Kelly's family. When it came to the Harvey Weinstein trial, no one of the media was sitting down with Harvey Weinstein. Listen, I am just giving my commentary on a publicly available document. Shout out to document teams on Twitter. They are the GOAT. The GOAT. The GOAT when it comes to legal papers, for sure. And I always credit my sources, as we all should, because if you did the hard work, you deserve the credit. Amen. Amen. Let's keep going. Trial exhibit J25 defendant's live stream claiming to be one of 4 women sitting on Mr. Peterson's side of the courtroom as family. So you say that you knew media, but yet on a live stream you said that you were sitting with the Peterson on the Peterson side of the courtroom as family. A journalist doesn't say that they're family of a person that they're covering. But the mob is so smart, though. The supporters of Milagro are so smart. Milagro is so smart. Okay. Let's keep it going. Defendant also appeared at Mr. Sunstar Peterson's impromptu press conference outside the courthouse, not as a reporter in the press asking questions, but rather as a proud daughter and sister standing alongside the Peterson family, making undeniably clear where her allegiance lied. See trial exhibit J21, December 23rd, 2022 Instagram post. The shade room showing defendant with the Petersons at a post-verdict press conference. And Milagro has said in live streams that, you know, if y'all can't see how he's like a dad to me, then I don't know what to tell you. She has said that in live streams. So just keeping it a buck with y'all here. Even after Mr. Peterson sat in prison as convicted felon for empowering plaintiff, defendant not only made contact with him, but crossed the line no disinterested report would. She flirted with Mr. Peterson, report her information status instead of discussing legal strategies, alleged new evidence, investigating facts remain to Mr. Peterson's bill, or even Mr. Peterson's music career. Any other news, defendant Mr. Peterson shared love notes, compliment one another's looks, and expressed mutual adoration. Unadmitted trial exhibit J383 defendants June 2nd, 2024 Instagram direct message with Mr. Peterson. Mr. Peterson looking fire still. Defendant, I know you were in their trauma. Whoever crosses your path, I love you. When plaintiff first sued defendant, she hired the same law firm, Unite the People, that represents Mr. Peterson in his appeal. She did so despite recognizing there might be a conflict of interest. And not to mention too, she cannot pay that organization. She cannot pay that organization of Unite the People. And also, too, one of her attorneys just dropped off the case. And that same judge that was in the trial approved that because Milagro is broke $10,000 in the hole. Her words. Now, I know what everybody's saying. Good damn, Braylon. Really? You covering this shit again? Yes, I am. Because we all knew, well, the ones that were smart enough to know that this was going to be far from over. Because that's the thing. Everybody thought, okay, the verge was the verdict. No. It is fine-tuning everything after the verdict. That's where the real work begins. So, and not to mention, this case is a huge media story, right? So it's dealing with politics, it's dealing with race, it's dealing with culture, it's dealing with entertainment, and it's also dealing with the creator economy. So, and not to mention too, it's like she a public figure, so it comes with the territory. You know what I mean? So you can't be that big outside where you can talk about everybody else, but nobody can talk about you. Even Wendy Williams, right? As much as Wendy Williams did this, that, and the third, when it came to what she and Kelvin Hunter went through, she said, no, it's only fair to talk about me. I talk about everybody else. So even Wendy Williams understood the assignment, right? So, yes, indeed. Hopefully, her conservatorship ends this year, and 2026, we'll see Wendy Williams outside. Yes, indeed. Let's see here. Steve Milagro Cooper trial 140, 16 through 18, November 18th, 2025. Question, and did you talk about potential conflict of interest because they unite the people also represent Taurus? Oh, no. Let me get myself. Ooh. Getting older, child. Getting older. But it's a blessing to still be here. Answer, I believe I brought that up. Caesar McDowell deposition trial 2023, 2021, November 19th, acknowledging that he recalls hearing that Mr. Peterson asked about potential conflict of interest, but claimed to not remember why it would be a conflict. Also see trial exhibit J 433.317 through 19. Defendants December 18th, 2024 text with Sunstar discussing how to explain away $3,000 in payments. Sunstar, great, very good, but you should send it to the lawyers. I'm waiting to hear from Caesar, CEO of United People. Why would you have to explain away $3,000 payments if you are a journalist? I mean, this is given when 47 used campaign funds to pay off an Orange Star. My Lord Jesus. Holy. Okay. Right here. Defendant promotes her personal brand. This is B. Defendant promotes her personal brand with biased partial commentary favorable to Mr. Peterson. Defendant built her mob radio brand off of defaming plaintiff. See Megan P. trial 17/24/18.1. .1 November 21st. She's famous because she's talking about Megan Thee Stallion in Tory Lane's case. She got famous and known for trashing me. Trial exhibit J 486 defendants. June 9th, 2024, live stream about two influential now is what I come to realize. Emil Holland Briggs trial 28/14/29/14, November 20th, 2025, testifying that defendants' dangerous cult-like following and further perpetrates anything defendants disseminates. At 30/14 through 17, it was almost like a daily segment about plaintiff, to be honest with you. Defendants' obsessive coverage of plaintiff, particularly concerning plaintiff's private affairs such as the family background, alleged mental capacity, or alcohol consumption, undercuts her argument that she operated for the purpose of informing the public on matters of concern. Rather, defendant built a social media business centered around smearing plaintiff's reputation. Now, with that being said, let me show y'all something, right? Because I know Milagro, the mob, her support is going to be like, oh my God, all you do is talk about her, da-da-da-da. It was just like the Kenya Moore thing. Some people thought I was a Kenya Moore hater. Child, it was a cultural experience. Everybody was waiting for Kenya Moore's confessions. But let me show you what I do. Here it is, okay? We got the jumper crawl tonight. Cannot wait for y'all to see that format. But then we have this one that you're watching here. Christmas check-in, did that yesterday. Milagro Gramz on Marlon Wiggins break down Townhall, Married to Medicine, Nicki Minaj, Potomac, Stars, Ready to Love, Wendy Osefo, Eddie Osefo, CBS, Charlamagne the God, Jelly Roll, Courtney B. Vance, Kristen Cabot. Let's see here. TikTok. Oh, we talked about thighs. Yes, of course. Then we talked about TikTok and Universal. TikTok right here. The Oscars. Warner Brothers, RK1 Up, Twitter, Jack in the Box, Megan Thee Stallion, TikTok again, Six Flags, Barry Weiss, CBS News, OWN, Ray J, Lizzo, New York Radio, Universal Parks and Resorts, and the CEO Club with Serena Williams, Funky Dineva, Tasha Dickerson, Rita Ora, Zido Beatery, Jasmine Carr, DJ Crystal Devon, Nursing and Ba TV, Usher, Jacqueline Carr, Gene Cersei, Academics or PDF Academics, Michael Virgil, Erica Banks, Ray J, and Demi Perry. So do you see how we have content over here that is speaking about anything and everything, and that's not going after one particular person? Okay. Here's the trial covered every day. The Braxtons, Britt Eady, Universal Epic Universe, talking about Wicked, talking about Wicked 3 movie breakdown, if there's the potential for that. Talked about Bravo right there. celebrating 12 years of our channel, speculating about Epic Universe, Six Flags. Right here, that's 1, 2, 3, 4, 5, 6, 7 different topics there. Brainley's Virtual Tour House Tour, Epcot Resort, Funko rebrand. So you see how where it's with me, no one can sue me because I'm not going after one particular person compared to Milagro, right? So when Milagro says, oh, I never meant to hurt her, this, that, and the third, you said, and I quote, I ain't taking nothing back and sue my ass. That's what you said, right? So let's get back to this motion here. Right here. C, defendant conceded she's not a journalist. Defendant repeatedly admitted throughout trial that she's never been a journalist. She's disclaimed any any affiliation with traditional journalists or reporters, and admits she's never looked into the ethics required for journalists. Milagro Cooper trial 252 6-7 November 24, 2025. Defendant does not believe that the journalistic code of ethics apply to her. She will only follow them if they will rework to comply with her understanding of the way the world works now. So you could understand the weight of what you've done. What makes you think you're going to follow rules if they're reworked for you? Because if you couldn't follow the basics, what makes you think somebody's going to rewrite the rules so you can get away with more bullshit? I'm just asking a question. That's all I'm doing here. I'm just asking a question. Here we go. Milagro Cooper trial 12/1-3, November 25th, 2025. Defendant also made prior statements on her live streams disavowing any claims to being a journalist. I'm going to read all of this 3 times, okay? Here we go. At what point in time haven't I told you to go do your own independent research? At what point in time hasn't this show read that this was for entertainment purposes? At what point in time did you really think I was getting up here and I told you I have a psychology and a criminal justice degree? I ain't never told you I went to school for journalism. What fucking article did I write that I posted and said, y'all read this? What the fuck are y'all talking about? I don't think I'm anything, but I know I'm a person that gets under your skin. You don't need to be a journalist to see something, give an opinion on it. So my whole thing is, if I'm not trying to be a journalist, and you know I'm not, what the fuck you mad about? Because I shouldn't be regarded as a news source any damn way. I'm going to read that 2 more times. At what point in time haven't I told you to go do your own independent research? At what point in time hasn't this show read that this is for entertainment purposes? At what point in time did you really think I was getting up here and I told you I had a psychology and criminal justice degree? So you have a criminal justice degree, but yet you got your ass caught up based on your own bullshit, and you couldn't understand the psychology of caring about another fucking human being's feelings, thoughts, and emotions. But yet you're new media. Let's keep going. I ain't never told you I went to school for journalism. What fucking article did I write that posted and said, y'all read this? What the fuck are y'all talking about? I don't think I'm anything, but I know I'm the person that gets under your skin. You don't need to be a journalist to see something, give an opinion about something. My whole thing is, if I'm not trying to be a journalist and you know I'm not, what the fuck you mad about? Because I shouldn't be regarded as a resource any damn way. One more time. For the one more time. At what point in time haven't I told you to go do your own independent research? At what point in time hasn't this show read that this is for entertainment purposes? At what point in time did you really think I was getting up here and I told you I have a psychology and criminal justice degree? I ain't never told you I went to school for journalism. What fucking article did I write that I posted and said, y'all read this? What the fuck are y'all talking about? I don't think I'm anything, but I know I'm the person that gets under your skin. You don't need to be a journalist to see something with an opinion about. So my whole thing is, if I'm not trying to be a journalist and you know I'm not, what the fuck you mad about? Because I shouldn't be regarded as a news source any damn way. Okay. Trial Exhibit J562, defendants, October 30th, 2024 live stream. Also see Milagro Cooper trial, 10/17 through 19, November 25th, 2025. In that same live stream, defendant again disclaimed Any connection to being a journalist, being a journalist, claiming everything is not meant to be a news report. I did not tell anybody I was a reporter. Everything is not meant to be a news report. I did not tell anybody I was a reporter. Everything is not meant to be a news report. I did not tell anybody I was a reporter. Defendant instead characterizes herself as more of an entertainer. Wait a minute. Hang on. This is inside Milagro's mind, y'all. Here we go.
It's not just feeding the hungry only on Thanksgiving. It's an everyday situation. You know what I mean? This is 265 days a year.
That is funny. 265 days? Where the hell that bitch live at?
It's not.
Apparently that bitch lives in Houston, Texas. Let's keep going. Defendant instead characterizes herself as more of an entertainer. Defendant characterizes herself as more of an entertainer. Milagro. Well, I was about to say Milagro Crapper. Anyway, Milagro Cooper. It's been a long day, y'all. Trial 253, 12 through 18. November 24th, 2025. Indeed, defendant puts a disclaimer in every description box on all her videos, claiming that her shows for entertainment purposes only and shall not be deemed as fact or advice. Let me read that two more times. Defendant puts a disclaimer in every description box on all her videos, claiming that her show is for entertainment purposes only, shall not be deemed as fact or advice. Defendant puts a disclaimer in every description box on all of her videos, claiming that her show is for entertainment purposes only and shall not be deemed as fact or advice. Here we go. And by the way, it says here, see right here, also trial exhibit J336, defendants, July 30th, 2024, live stream, MID 256, 215, and then 85, 13 through 21. D, defendant disseminates false and defamatory messages intended to misinform the public. There is no dispute that defendant is a prolific content creator. The evidence at trial demonstrated that defendant's content was about plaintiff, which constituted the core of her online discussions, was false, biased, and defamatory. See ECF number 226. Defendant, no matter how regularly she released content, did not report on news or information related to matters of public concern. Instead, she was spreading rumor, speculation, and lies favoring Mr. Peterson and designed to obstruct justice in an effort to falsely exonerate him at the expense of plaintiff's reputation and emotional state. Indeed, every one of Tory's narratives that works in his favor has come from Milagro. Megan Pete trial 15, 13 through 14, November 24th, 2025. C trial exhibit J248. Defendants February 23rd, 2022. Twitter post breaking. It was revealed in court a few moments ago, but it was revealed in court a few moments ago that Tory Lane's DNA was not found on the weapon in the Meg Thee Stallion case. You should have just put the A in because it's Megan Thee Stallion, not Meg the Stallion. You are a supposed journalist. Listen, Megan Pete trial 135, 19 through 22, November 20th, 2025. So Milagro tweeted this before court, and it's just what everybody still believes to this day. People still think that Tory did not pound me because Milagro tweeted that his DNA was not on the pound. That's not true. Trial exhibit J299, defendants July 30th, 2024, live stream claiming, I believe that the damn girl stepped on glass or ricochet shit came and fucked up. Whatever you say happened, I don't believe it. So you got to work under the skies that I don't believe that she got harmed that way. I'm going to read that two more times. I believe that the damn girl stepped on glass or ricochet shit came and fucked up. Whatever you say happened, I don't believe it. So you got to work under the skies that I don't believe that she got harmed that way. One more time. I believe that the damn girl stepped on glass or ricochet came and fucked up. Whatever you say happened, I don't believe it. So you got to work under the skies that I don't believe And I don't believe she got harmed that way. Now, why am I repeating that, right? Because as a journalist, you are supposed to give the facts as they are. As a journalist, you cannot say, I don't believe you, or I do believe you, right? And number two, journalists are supposed to inform. Journalists are supposed to inform. Journalists are supposed to inform, not persuade. Well, hey, listen, what do I know? I'm just a black man talking on YouTube. Not like we're getting close to 1 million views or anything off of integrity, accountability, and responsibility or anything. Oh, wait, we are getting there. Oh, my Lord Jesus, Milagro trial, 71, 3 through 5, November 18, 2025, claiming she was merely posing a question by falsely claiming the POW and bullet fragments were missing. Procedural background: the only time defendant raised the media defendant issue prior to trial was at the pleading stage in her motion to dismiss. CECF number 30, the court disagreed with defendant and denied her motion on that ground. CECF number 36, the court relying on the well-pled facts, found that defendant lacked media status because he was a longtime mouthpiece for Daystar Pearson, plaintiff's assaulter, and his father, Sunstar. Number 2, worked in concert with Pearson to harass and discredit plaintiff on Pearson's behalf. And number 3, publicly admit that she's not a journalist. Defendant never moved for reconsideration of the court's ruling, nor defendant moved for summary judgment at all, let alone that she was a media defendant entitled to receive notice. Let me read that 2 more times. Okay, let me read that 2 more times. The only time defendant raised the media defendant issue prior to trial was at pleadings in her motion to dismiss. The only time defendant raised the media defendant issue was prior to trial was at the pleading stage in her motion to dismiss. So here's the thing, right? She came on big, bad, and bold, this, that, and the third, just like Tasha K. I'm gonna wipe my ass with the cease and desist, right? We all remember that. If you didn't do nothing wrong, why were you trying to file a motion to dismiss? If you did nothing wrong, why were you trying to file a motion to dismiss? If you did nothing wrong and you went after what you believed in, supposedly your words, and you are protected under the freedom of speech of the First Amendment, freedom of speech, then why did you file a motion to dismiss? Why did you try to become a media defendant if you did nothing wrong? Why did you try to become a media defendant if you did nothing wrong? Why did you try to become a media defendant if you did nothing wrong? Okay. I'm just asking questions here, ladies. That's all I'm doing. That's all I'm doing. There we go. Yes, indeed. Here, let's get back to this. 3 things. Number 1, she's a longtime mouthpiece for Daystar Pearson, plaintiff's assaulter, and his father, Sunstar. Number 2, worked in concert with the Pearsons to harass and discredit plaintiff on Pearson's behalf. And number 3, publicly admitted that she's not a journalist. Number 1, she's a longtime mouthpiece for Daystar Pearson, plaintiff's assaulter, and his father, Sunstar. Number 2, worked in concert with the Pearsons to harass and discredit plaintiff on the Pearsons' behalf. And number 3, publicly admitted that she's not a journalist. I want to just zoom in on number 3 real quick. Publicly admit that she's not a journalist. Publicly admit that she's not a journalist. Publicly admit that she's not a journalist, which would mean that she could not be a media defendant. Because when we pulled up the definition according to Google, Google said that a media defendant is not necessarily a journalist. And you really want to go up against a media nerd of social media. Oh, Lord, let's keep it going. Defendant never moved for reconsideration of the court's ruling, nor did defendant move for summary judgment at all, let alone on the basis that she was a media defendant who would be entitled to pre-suit notice. At the October 30th, 2025 pre-trial conference, defendant again chose not to raise the media defendant issue. Let me say that 2 more times. Defendant again chose not to raise the media defendant issue. Defendant again chose not to raise the media defendant issue. So Milagro didn't even consider herself media. She didn't even consider herself media. She didn't even consider herself media, right? Let's keep going. CEF number 172 pretrial conference, October 30th, 2025. It was only at the final pretrial conference on November 10th, 2025, after the close of pleadings, discovery, summary judgment, and prior pretrial conferences, that defendant re-raised the media defendant issue and requested to leave to brief the issue on whether plaintiff was required to prove actual damages on her media defendant claim. So you had from October 30th to November, so October, November, basically a month and some change, to raise the media defendant issue. And after the pleadings, right, the discovery of everything, including those deleted messages that you tried to get rid of because you know your ass was guilty, the summary judgment of, what, each party wants, and then the prior pretrial conferences to work out everything. After the work's been done, and you saw that your work was going to fuck you up, then you want to raise the media defendant issue after the evidence was already put out. Okay, child. On the first day of trial, after the jury was seated before opening statements commenced, the court agreed again with the plaintiff that defendant does not qualify as a media defendant. On the first day of trial, after the jury was seated and before opening statements commenced, the court again agreed with the plaintiff that the defendant does not qualify as a media defendant. One more time for all the people in the back. On the first day of trial, after the jury was seated and before opening statements commenced, the court again agreed with the plaintiff that the defendant does not qualify as a media defendant, and found, consistent with my ruling in the order on the motion to dismiss, the defendant is not a media defendant. And found, consistent with my ruling in my order on the motion to dismiss, the defendant is not a media defendant. Consistent with my ruling in my order on the motion to dismiss, the defendant is not a media defendant. Child, listen. I'm just reading it. That's all I'm doing. I'm just reading it, you hearing it. Okay? That's all we're doing here. Trial, 97-16 through 25, November 17, 2025. Unlike at the pleading stage, the court based its ruling with the full benefit of the evidentiary record. It considered defendant's own statements made during her depositions, as well as her live streams disclaiming any characterization as a journalist. It considered defendant's own statements made during her depositions, as well as her live streams disclaiming any characterization as a journalist. It considered defendant's own statements made during her depositions, as well as her live streams disclaiming any characterization as a journalist. CEEF number 183. Nonetheless, on the fifth day, good Lord Jesus, man. On the fifth day of trial, defendant had testified. Her counsel again sought to re-inject the twice rejected media defendant issue. Okay. So on the fifth day, Milagro's counsel wanted to try the media defendant issue again. That's like, I'm just going to say it. Milagro is the female version of P. Diddy in this fact that I'm about to say. although Milagro Gramz has a SA lawsuit that has some energy of P. Diddy, that's neither here nor there, but a very important point to know. Here's where I'm saying Milagro is the female version of P. Diddy, right? Remember how Diddy has been trying to get out of jail for so long, and he's been filing motions, this, that, and the third, even though Judge Arden Samiri rejected it so many times already? Hello, birds of a feather flock together. I'm just saying. For it to be rejected twice of the media defendant issue, and Milagro's counsel sought to re-inject it again, they knew early on in the trial that Milagro Gramz fucked herself up the asshole with no lube and she's bleeding. And they could not do anything to soothe her pain. All right. See trial 108-13, November 21st, 2025. After the parties submit briefing and met and confirmed, the court held that issue would be submitted to the jury subject to post-verdict briefing. See ECF numbers 183-207, 208, 211. Plaintiff then sought to preserve and raise the issue after the defendant's case in chief pursuant to federal P code. I believe that's it. Federal Reserve civil penalty 50. I believe that's how you say it. But hey, listen, if I butchered it, lawyers, let me know. Okay, I know just Jonda is a great lawyer. I know that she is very productive as always. So, by the way, like, comment, share, subscribe to Just Jonda, a great system for sure. The court advised the plaintiff could reserve on the motion. See trial 122-5-9, November 25th, 2025. Later that day, at the final charging conference, when jury instructions were being finalized, the court determined that the effects of the defendant's purported media defendant status was not for the jury to decide. Okay? So when this happened, right, on the last day, that was for the jury to decide if Milagro was a media defender or not, as an advisory suggestion for the judge. Let me say that two more times. The jury was supposed to check yes or no if Milagro was supposed to be a media defendant as their recommendation suggestion for the judge to, glean from. One more time. The jury decided if Milagro was a media defendant, not to define defamation, but as a advisory recommendation to the judge. Okay? Because remember how, everybody, well, not everybody, child, but a very mob cult, how can I put it? A very select group of mob radio cult-like people kept saying, well, she's new media. The jury decided. No. It was on an advisement to the judge. Okay. So right here, let me go back. Later that day, the final charging conference, when jury instructions were being finalized, the court determined that the effects of the defendant's report media status were not for the jury to decide. Let me read that one more time. Later that day, at the final charging conference, when jury instructions were being finalized, the court determined, not Mabreo determined, not Milagro determined, not Milagro's counsel determined, not her supporters determined, not anybody who believed their social capital could have the weight of being felt to make a decision decided. It was the court that decided that the effects of the defendant's purported media defendant status were not for the jury to decide. Right here. Court, in your proposed jury instructions that I reviewed, you now have my edits on. I did not include language regarding effects of media defendant status. Somebody did. I don't think that's a jury issue, what the effect of their finding is. I don't think that's a jury issue what the effect of their finding is. I don't think that's a jury issue what the effect of their finding is. So whatever effect of their finding is, whether they believe she was a media defender or not, that was what they were supposed to do. They were supposed to give their opinion of if Milagro was a media defendant, not to decide if she was a media defendant. That would be up to the judge. Okay. Plaintiff clarified that the purpose of including language on potential consequences in jury instructions was to clarify for jurors, even if the defendant was media defendant, that plaintiff would still be entitled to actual damages with the court, which the court affirmed as a question of law and not a jury issue. Court, right? It is not a jury issue. Right? It is not a jury issue. Right? It is not a jury issue. The court then reiterated that it would address the consequences of a media defendant finding post-verdict. The court then reiterated that it would address the consequences of a media defendant finding post-verdict. The court then reiterated that it would address the consequences of a media defendant finding post-verdict. Okay, let's keep going. November 26, 2025, the jury began deliberations. On December 1st, the jury rendered a unanimous verdict in plaintiff's favor on all three of her claims: 1, defamation per se; 2, intentional infliction of emotional distress, IIED; and 3, promotion of an altered sexual depiction. Let me read that 3 more times for everybody in the back who thought Milagro won. Let me read it 3 more times. On November 26th, 2025, and by the way, today is the 1-month anniversary since the verdict. Today is December 26th, 2025. There it is. On November 26th, 2025, the jury began deliberations. On December 1st, the jury rendered a unanimous verdict. Unanimous means everybody agreed. From Mabreo, I know everybody in Mabreo didn't finish high school. Probably didn't go to college. Some of y'all got your GED, which nothing wrong with GED. Life is life. But we're talking about comprehension skills and understanding. If you can see that when somebody fucks up, there are consequences for what they do. So what they do plus how they move equals consequences. What they do and how they move equals consequences. What they do and how they move equals consequences. Right? So we know some of y'all were just basic on your state placement test, but that's neither here nor there. Let's roll on. One more time. On November 26, 2025, the jury began deliberations. On December 1st, the jury rendered a unanimous verdict in the plaintiff's favor on all 3 of her claims: defamation per se; 2, intentional infliction of emotional distress, IIED; and 3, promotion of an altered sexual depiction. On November 26, 2025, the jury began deliberations. On December 1st, the jury rendered a unanimous verdict in the plaintiff's favor on all 3 of her claims: number 1, defamation per se; number 2, intentional infliction of emotional distress, IIED; and 3, promotion of an altered sexual depiction. Specifically, with regard to plaintiff's defamation per se claim, the jury found that 1, defendant defamed plaintiff. Let me read that 2 more times. The jury found that defendant defamed plaintiff, that Milagro defamed Meg. Okay. Number 2, such defamation caused plaintiff actual damages. Such defamation caused plaintiff actual damages. Such defamation caused plaintiff actual damages. I'm just reading it. That's all I'm doing. I'm just reading it. I am just reading it. Okay. That's why I titled this live, Megan the Historian. Did you forget your words? The Milagro Gramz Reinstatement Breakdown Townhall, because we're breaking down this motion to reinstate the defamation claim. Okay? That's what we're doing. CECF number 226, questions 1 and 2. The jury also found defendant did not provide disinterested and neutral commentary, rather advocacy for a particular client or personal interest, and did not impartially disseminate information, but rather acted primarily to promote her own business products or services. Let me read that 2 more times. The jury also found that defendant did not provide, did not, D-I-D-N-O-T, did not provide disinterested and neutral commentary rather than advocacy for particular client or personal interest, and did not impartially disseminate information, but rather acted primarily to promote her own business products or services. The jury also found that defendant did not provide disinterested and neutral commentary rather than advocacy for a particular client or personal interest, and did not impartially disseminate information, but rather acted primarily to promote her own business products or services. ECF number 226, questions 3 through 5. Despite finding that defendant failed to provide disinterested, neutral, and partial commentary and used her platform for her own business interest, the jury determined that defendant qualified as a media defendant. Qualified, which means just like you apply for a job. Oh, congratulations, you met the qualifications, but she did not get approved as a media defendant. She was qualified as a media defendant, but she did not get approved as a media defendant. She got qualified as a media defendant, but she did not get approved to be a media defendant. Okay. It says here, despite finding the defendant failed to provide disinterested, neutral, and partial commentary and use her platform for her own business interests, despite finding that defendant failed to provide disinterested, neutral, and partial commentary and use her platform for her own business interests, rather. Okay. Throughout jury deliberations, the jury had expressed confusion as how to properly evaluate media defendant factors. Just want to read that 2 more times. The jury had expressed confusion as to how to properly evaluate the media defendant factors. The jury had expressed confusion as to how to properly evaluate the media defendant factors. See ECF number 237. We are confused. If we believe half of the factors, is that considered a yes as to defendant media status? In response, plaintiffs sought to advise the jury, while no one factor is positive, whether a defendant is disinterested, neutral. Answer to question 3 on the verdict form is the most important factor under the circuit's precedents. Plaintiff's counsel trial 5-4-6-2. December 1st, 2025, plaintiff also sought to advise the jury that answering yes to a majority of questions 3 through 7 does not mean that you must answer to question 8 that defendant is a media defendant. I'll say that again. Plaintiff also sought to advise the jury that answering yes to a majority of questions 3 through 7 does not mean you must answer yes to question 8 that defendant is a media defendant. Plaintiff also sought to advise the jury that answering yes to a majority of questions 3 through 7 does not mean you must answer yes to question 8 that defendant is a media defendant, and vice versa. So, if they answered questions 3 through 7, but they checked, no, she is not a media defendant, then there it is. So basically on question 8 is the defining question that determines the yay or nay. So question 8 is the question that defines all. Question 8 is the question that defines it all, and vice versa. Defendant, while agreeing that no one factor is outcome determinative, arguing that a finding for half of the factors would mean defendant qualifies as media defendant. Defendant's counsel, ID at 6-3-13, the court ultimately instructed the jury that there is no set number. ECF number 237. The jury, as such, did not receive further guidance as to which specific factors should be given greater weight than others. Therefore, the court entered final judgment on counts 2 IIED and counts 2 and 3 promotion of an alter sexual depiction, but not on count 1 defamation per se. So we got all that. Okay, now I know that was a lot, but basically it's just saying, bitch, you fucked your own self up by saying you're not a media defendant, saying that you were a daughter and you got paid. That's basically all that is, right? Everything that I just read. And also, too, that question 8 was the defining question, and that Milagro was found guilty on all 3 counts, okay? So here's the memorandum of law. Number 1, legal standard pursuant to federal R civil P59E, a party may seek to alter or amend the judgment if a motion is filed within 28 days after the entry of judgment. The court may grant a Rule 59E motion to correct clear error of law or fact or to prevent manifest injustice. We'll do that 2 more times. Pursuant to federal R civil P59E, a party may seek to alter or amend a judgment if a motion is filed within 28 days after entry of judgment. The court may grant a Rule 59E motion to correct clear error of law or fact or to prevent manifest injustice. Pursuant to federal R civil P59E, a party may seek to alter or amend a judgment if a motion is filed within 28 days after entry of judgment. The court may grant a Rule 59E motion to correct clear error of law or fact or to prevent manifest injustice. So, I don't know if this is true or not, but this is my logic, right? It's almost like if you are getting sued, right, and you have a court date. If you don't show up, then the other party wins automatically. So, within 28 days of this, right, within 28 days of this, if Megan and her team do not respond to this, could that mean potentially? Now, I'm not saying this is a fact, okay? So listen. But could this mean that potentially that Megan wins defamation, right? If that is the case. Give me a moment, y'all. Okay, so here it is here. So shout out to the courtlistener.com. So this is courtlistener.com right here. Court Listener by free.law. Now I'm going to scroll down here. Now, like I said, this is just my commentary, right? Responses due by January 6th of 2026. Now, if Milagro and her team, which I believe are still working for free, do not respond by that time, right? Now, you can respond on that day still, January 6th, 2026. But if you do not respond, could that mean that Megan gets the default judgment on defamation? Let me type that. If you do not respond to a claim, to a motion, does that mean a default judgment? Okay, here it is here. Here it is here. Yes, generally failing to respond to a lawsuit's initial complaint or critical court motions can lead to a default judgment. Let me zoom in here. Yes, generally, failing to respond to a lawsuit's initial complaint or critical court motions can lead to a default judgment. Yes, generally failing to respond to a lawsuit's initial complaint or critical court motions can lead to a default judgment where the court rules in favor of the moving party, granting them what they asked for, as you've essentially forfeited your right to contest the claims. However, it's not always automatic. The other side must file a formal motion for default judgment, and courts have discretion to set aside a default if you show good cause, like not being properly notified or a genuine mistake. So critical court motions. Let's go back to this, right? Because right here it says party may seek to alter or amend a judgment if a motion is filed within 28 days after entry of judgment. So after those 28 days, if Milagro Gramz and her team does not respond, and this is a critical court motion, this could lead to a default judgment where the court will rule in favor of Megan Thee Stallion. Okay? All right, let's keep going. Similarly, under Federal R Civil P 60B provides that a court may grant a post-judgment motion under certain circumstances. Number one, mistake, aberrant, surprise, or excusable neglect. Number two, newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial under Rule 59B. 3, fraud, whether previously called intrinsic or extrinsic, misrepresentation or misconduct by an opposing party. 4, the judgment is void. 5, the judgment has been satisfied, released, or discharged. It is based on earlier judgment that has been reversed or vacated, or applying it respectively, it is no longer applicable, or any other reason that justifies relief. So right here, I believe that right here, number one, mistake, inadvertent, surprise, or excusable neglect. So to me, this was a mistake, right? Because the jury was confused on the questions. And I do think it was excusable neglect because you have a paper trail of the court saying that Milagro is not a immediate defendant. So I believe that number one is the main worm that they are using to hook in this fish. I believe number one, mistake, advertence, surprise, or excusable neglect. Mistake, and inadvertent, surprise, or excusable neglect. I think number one is the one that they're using to hook this fish in. I think number one is the word that they're using to hook this fish in. Right here, a mistake contemplated by Rule 60B1 encompasses a judge's errors of law and applies to misconception, misunderstanding, or fault in opinion or judgment. Kemp versus United States. That's not Kempire, everybody, okay? Shout out to Kempire, though. Like I'm just subscribe to Kempire. A mistake also encompasses the ordinary legal means to include a judge's mistakes of law or fact. Similarly, a Rule 59E motion gives a district court the chance to rectify its own mistakes in the period immediately following its decision. Bannister versus Davis, 590 U.S. 504, 508, 2020. Okay. Right here. Rule 60B6 is the catch-all ground for relief and allows for relief for any other reason that justifies relief. Rule 60B6 is available when there is a risk of injustice to the parties or a risk of undermining the public's confidence in the judicial process. The decision to grant a Rule 59E or 60B motion is committed to the district court's sound discretion. So the district court has wide jurisdiction under Rule 59E. Rule 59E is this right here. Encompasses a judge's errors of law and applies to misconception, misunderstanding, or fault in her opinion. fault in opinion or judgment. So because the paper trail was created by Milagro Gramz, and because it was a paper trail followed in this legal pursuit of justice, that there has been implications to showcase that Milagro Gramz is not a media defendant, then therefore it goes to the misconception, misunderstanding, and the fault in the opinion and judgment of this judge. Damn. They really did their work on this one, child. Rule 60 should be liably construed in order to do substantial justice. Lastly, under Federal R Civil P 50B, a movement may file a renewed motion for judgment as a matter of law after trial. The standard for granting a renewed motion for judgment as a matter of law under Rule 50B is precisely the same as the standard for granting the pre-submission motion under Rule 50A. Thus, as with motions under Rule 50A, the question for the district court confronting a renewed Rule 50B motion is whether evidence is legally sufficient to find for the party on that issue. Stated differently, entry of judgment as a matter of law under Rule 50B is appropriate when a party presents no legally sufficient evidentiary basis for a reasonable jury to find for him on a material element of his cause of action. Number 2, the MTD order decided the controlling legal issue became the law of the case for trial and post-trial proceedings. The well-established law of the case doctrine prohibits the relitigation of legal issues previously decided in the same case. This policy ensures that there will be an end to litigation by foreclosing the possibility of repeatedly litigating an issue already decided. When a court decides upon rule of law that the decision should continue to govern the same issues in sequential stages in the same case. This doctrine is designed rather to further important goals filed to just and efficient judicial process, including the provision of an end to litigation and the discouragement of panel shopping and the promotion of consistency in rules between courts. The MTD order did more than merely allow this case to proceed. It resolved a discrete legal question central to liability: whether defendant is a media defendant entitled to statutory pre-suit notice under Florida Statute 770.01, which the court clearly and unequivocally decided the defendant was not. The MTD order, hang on, let's see. Motion to dismiss, there we go. Motion to dismiss order did more than merely allow this case to proceed. It resolved a discrete legal question, essential liability, whether defendant is a media defendant entitled to statutory pre-suit notice under Florida Statute 770.01, which the court clearly and unequivocally decided the defendant was not. The motion to dismiss order did more than merely allow this case to proceed. It resolved a discrete legal question central to liability, whether defendant is a media defendant entitled to statutory pre-suit notice under Florida Statute 770.01, in which the court clearly and unequivocally decided the defendant was not. So in that motion to dismiss, right, decide the legal controlling issue, it became the case for trial and post-trial proceedings. So because the media defendant was the law for the trial and post-trial proceedings, that motion to dismiss got denied, and Milagro's counsel tried to re-admit the twice dismissed issue. They're basically saying, you guys decided already that she was not a media defendant, and because you decided this, right, that should mean that this verdict is null and void. That's what I'm gathering here, right? So, let's see here. Had the court determined otherwise, count 1 of plaintiff's complaint would have been dismissed. C. Buckley Moore, 2021 WL3173185. SD, Florida, July 26, 2021. Dismissing defamation claim due to insufficient pre-suit notice, saying ordinarily a plaintiff's failure to comply with the pre-notice requirement requires dismissal of complaint for failure to state a cause of action. Sir versus Oski, SD, Florida, October 25th, 2025, denying motion to dismiss, finding defendant is not a immediate defendant entitled pre-suit notice. Had count one been dismissed for this reason, the plaintiff could have and would have provided pre-suit notice in order to cure this defect in its pleading and thereafter refile its defamation. C. Barbardo versus Miami Herald Media, September 17th, 2021. If only if the time to comply with the statutory precondition has been expired should the action be dismissed with prejudice. Only if the time to comply with the statutory precondition has expired should the action be dismissed with prejudice. Only if the time to comply with the statutory precondition has expired should the action be dismissed with prejudice. However, the court's correct determination that defendant was not a media defendant obfuscated the need for any pre-suit notice. However, the court's correct determination that defendant was not a media defendant obfuscated the need for any pre-suit notice. However, the court's correct determination that defendant was not a media defendant obviated the need for any pre-suit notice. Okay, so obviated means remove a need or difficulty. So, with that being said, however, the court's correct determination that defendant was not a media defendant removed the need for any pre-suit notice. However, the court's correct determination that defendant was not a media defendant removed the need for any pre-suit notice. However, the court's correct determination that defendant was not a media defendant removed the need for any pre-suit notice. So, if the court had decided that Milagro was a media defendant, then officially the defamation claim would have been thrown out. But because it was decided in the pre-trial and the discovery and everything in between that Milagro was not a media defendant, then guess what? Basically, Megan did what she needed to do, and she deserves the defamation claim reinstated. No exception authorizes a departure from the motion to dismiss order. Clay identifies three narrow exceptions: substantially different evidence, number two, inadvertent change in controlling law, or three, clear error in prior ruling producing a manifest injustice. So, I do believe all three of these are at play. A clear error in the prior ruling producing a manifest injustice, that is very true. And also two, defendant did not provide any different evidence and intervening change in controlling law. So the intervening change in controlling law here is that the court determined that she was not a media defendant. So because of that judgment from the court officially, that showcases a change in the controlling law of the defamation being in place. Defendant presented no new or substantially different evidence bearing on her status that would justify relitigating of the threshold condition precinct precedent preceding question. Rather, there was no intervening change in controlling of law. Only manifest injustice here would be the nullification of the merits based on pre-suit notice requirement the court already had inapplicable. Indeed, the purpose of Florida Statute 770.01 is to afford newspapers and periodicals the opportunity to make a full retraction or is to afford newspapers and periodicals an opportunity to make full retraction in order to correct and avert errors or mitigate damages, as well as to save them the expense of answering to an unfounded suit for liable. I just want to zoom in here to newspapers and periodicals. Right? Right here. Right here. They really did their big one. Right here, periodical. A magazine or newspaper published at regular intervals. Similarly, right here, journal, publication, magazine, newspaper, paper, review, digest, gazette, newsletter, organ, serial, annual, quarterly, monthly, bi-weekly, fortnightly, weekly, bi-weekly, mag, book, or glossy. None of these similar words say content there. This says magazine or newspaper published at regular intervals, not video or audio published at regular intervals. Not video or audio published at regular intervals. Not audio or video published at regular intervals. That is what periodical is, everybody.
Periodical. 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 Periodical.
Sorry, y'all.
Periodical.
One more
Periodical.
time. One more
Periodical.
time. One more time.
Periodical.
One more time for the one more time for the one more time.
Periodical.
Okay, let's roll on. One more time.
Periodical.
Let's get back to this damn motion. Anyway, let's roll on. My Lord Jesus. In other words, it was never the intent of the Florida legislature to have parties in a defamation action proceed all the way through trial only to strike a defamation claim for failure to provide a pre-suit notice. In other words, it was never the intent of the Florida legislature to have parties in a defamation action proceed all the way through trial only to strike a defamation notice, defamation claim for failure to provide pre-suit notice. It was never the intent of the Florida legislature to have parties in a defamation action proceed all the way through trial only to strike a defamation claim for failure to provide pre-suit notice. So otherwise, because Milagro was determined by the court, in the words of Andy Cohen, it was determined that Megan Thee Stallion did not break any policies. Y'all remember that clip of Andy Cohen? It was determined by Bravo that you did not, that you didn't fail at that policy. Give me a moment. Hang on a second. Give me a moment. Here we go. Let me show y'all. I'm so fucking batty. Oh my Lord. Okay, here we go. So this is basically what happened with Megan Thee Stallion in terms of what's happening now. Like, y'all, cut the bullshit. But the biggest thing I want y'all to know is this. Andy, say it again for me.
On set, it was determined that you didn't violate that policy. So
say it again. What happened with Megan Thee Stallion? Andy, say it again for me.
On set, it was determined that you didn't violate that policy. So
one more time. For me.
On set, it was determined that you didn't violate that policy. So
it was determined that Megan Thee Stallion did not violate the rules of law for how she went after Milagro Gramz. Number 3, defendant waive and forfeit any attempt to re-inject statutory notice issue at trial and is equitably stopped from using it post verdict. Okay, child. What's stopped? All right. So in law, estopped from the principle of estoppel means being legally prevented or barred from asserting a claim, right, or fact because your prior words or actions, like a promise or omission, led to someone else reasonably relying on the cause and harm if you change your stance. Essentially, it stops someone from going back on their word, contradicting themselves when it would be unfair to another party, ensuring consistency and preventing injustice. So defendant waive and forfeit any right to re-inject statutory notice at trial and is basically prevented and barred from using it post-verse. So Milagro is basically legally prevented and barred. Milagro is legally prevented or barred from asserting a claim, right, or fact because your prior words or actions led someone else to reasonably rely on them, causing the harm if you changed your stance. So basically, she is barred from going back on her word or contradicting herself because it would look unfair to Milagro. Even apart from the law of this case, defendants attempt to resurrect the statutory pre-suit notice after litigation, losing it on the motion to dismiss, decline to seek reconsideration or in the declaratory review, and then trying the case on the merits was waived, forfeit, and barred by fundamental fairness. Plaintiff reasonably relied on the court's motion to dismiss or in defendant's silence in shaping discovery, trial preparation, and the presentation of evidence. The defendant never preserved this issue in the joint pretrial statement and never raised it at the October 30th, 2025 pretrial conference, only to spring it on plaintiff at the filed November 10th, 2025 pretrial conference and trial as a end run around the jury's ultimate decision in favor of plaintiff on her defamation claim. For this equitable estoppel doctrine exists to prevent exactly this sort of sandbagging. Party may not lull its opponent into strategic and legal posture and take an inconsistent position that inflicts substantial prejudice. See Major League Baseball versus Mafrati, Board 2001. Explain that the doctrine is applicable in all cases where one by word, act, or conduct willfully cause another to believe in the existence of a certain state of things and thereby induces him to act on this belief injustly to himself or alter his own previous condition to his injury. United Automobile Inc. versus Chiropractic Clinics, South Florida, recognizing the doctrine as a valid defense to limitations here and holding the doctrine applied to prevent insurer non-coverage based on alleged legal billing. Permitting defendant to do so here will not only reward gamesmanship, but will also risk converting defendant's belay maneuver into a limitation strap that wipes out defamation, plaintiff's defamation claim entirely. Equity does not tolerate this result. Damn. So basically, what this is saying here is because you don't want to deal with the consequences doesn't mean you can renege and now bring up the thing that can get you out of what you got caught up in. Let me say it two more times. So because your ass got caught up, and because of the rules of law, you cannot use the thing that could get you out of it because it will compromise the integrity of the verdict. Because you got your ass caught up, you can now not use the media defendant when you did not respond during the pre-trial, the discovery, everything else. Because you bringing that up would put it in a compromising position where now Megan could not get any of the $59,000 nor the $75,000. Bob Ray, are you listening? Y'all really thought this was over. This is how you do content. In the words of that person from Beyond Scared Straight, I heard about you. I saw you at the door. And listen, y'all, I am covering this from the basis of media, culture, and a human interest story that everybody's talking about. And also, too, I do think that content creators should be covering this thing because it does deal with the creator economy. It does. Last night we talked about Armand Wiggins being a part of a real list, fake list, whatever the fuck. It had Hot 97 on it. About him being potentially considered to be paid $250,000 over 3 years. And like I always say, if you understand the moves that are happening around you, you'll understand what you're seeing in front of you. If you understand the moves that are happening around you, you'll understand what you're seeing in front of you. If you understand the moves that are happening around you, you'll understand what you're seeing in front of you. And do y'all remember when Armand Wiggins said, y'all better hope that the deal I got, I don't accept it? I told y'all that he could have used that inch of that social capital of, hey, look, this is what I was potentially, this is why I could have been potentially offered that Hot 97 for $250,000 a year, for $250,000 rather, over the 3 years. Can y'all match that? Or can you be more than that? You know why the civil rights movement is so recognized? It's because they didn't talk about their titles. Like Milagro says, she's new media. They were just about it. I'm going to say it 2 more times. The reason why the civil rights movement was so recognized wasn't because of the titles they were holding on to. It was because they were about their business and handling the responsibilities of the movement. One more time. The reason why the civil rights movement was the movement wasn't because of the titles that they were claiming to profess to have. It was about them executing the responsibilities of what they need to do within the movement. Hey, D. Joyce, welcome in. Good to see you here. Milagro thought this was over. She celebrated too early, in my opinion. Yep. Whoop. And yes, they should. Let's keep going. Here we go. The media defended special derogatory was improper. A special derogatory cannot be used to override the court's controlling legal determinations. Status issues determining the choice of instructions relating to public figure, media defendants, and non-media defendants are commonly decided as a matter of law, therefore omitted from these instructions. Here, it did just that, override the court's determination as a matter of law that the defendant is not the defendant. Here, it did just that, override the court's determination as a matter of law is that defendant is not the defendant. Here, it did just that, override the court's determination as a matter of law that defendant is not the defendant. So basically, and this is a powerful statement I'm about to say. Even if the media defendant was actual, factual, smactual, it does not override the fact that Milagro was found guilty on all 3 counts and that she still has to pay $59,000. Let me say that 2 more times. That media defendant in derogatory, it does not override the verdict. The media defendant term does not override the verdict. It does not override the verdict. It does not override the fact that Milagro still has to pay. Because here's the thing. When Milagro said, I'm going to go in the studio and get out my, frustration, this, that, and the third, because anywhere else, it's, did you notice how she didn't deny the fact that she was found guilty? Let me say it 2 more times. In her first response, and even when she went on Mom Wiggins' channel, she did not deny the fact that she was found guilty and she's got to pay $59,000. She did not deny the fact that she was found guilty and still has to pay $59,000. I want everybody to listen to the quiet part that's not being said out loud. She was more concerned about the new media towel, but did not acknowledge that she was found guilty and has to pay $59,000. So even though she won, she really lost. It's almost like you playing in Smash Brothers with a CPU. You put your character in CPU mode. It does all the work, and then you win. Yay, I win. No, that's a false win, motherfuckers. That's a false win. So what she's doing with this new media shit is she is using this as a CPU or a non-playable character. She's using a non-playable character CPU and making that her win when really she didn't play the game. Because if she would play the game, that would really determine if she really won or lost. But because she used a non-playable character, because she used a CPU, she lost. Because a CPU or non-playable character can only do so much. Just like the law only allows so much. Let me say that 2 more times. A CPU non-playable character can only do so much. Just like the law can only allow so much. A CPU character or a non-playable character can only do so much as the law can only allow so much. She motherfucking lost. Let's get back to it. And don't worry, I know we still got Brainley's virtual tour jumper crawl. I cannot wait for y'all to see that. Okay, we're on page 12. The media defendant classification under Florida Statute 770.01 involves a similar court-centric inquiry as the court's determination of a defamation plaintiff's status as a public figure. The inquiry may involve the examination of facts, but the designation is also reserved for the courts. The designation is also reserved for the courts. The designation is also reserved for the courts, not the jury. Not the jury. Not the jury. Because remember how everybody was like, oh, the jury decided. Hey, our new media, the jury decided. Remember how Milagro said, I need y'all go and correct the record on what y'all said out here. Thank you. Love you. Yeah. Well, will you have enough of a vagina between your legs to say this shit on your show? But the designation is also reserved for the courts. The designation is ultimately reserved for the courts. Because here's the thing, right? Even with Tossaway K, no matter how much he tried to get out that payment, the courts had the final say-so on how Tossaway K was going to pay. Even though Tossaway K tried to do this, that, and the third, the courts had the final say. The courts had the final say. Not Tossaway K, the courts had the final say to determine how she was going to pay. So it wasn't the jury that decided that. That was an advisory recommendation to help the judge determine it, to make the final determination if Milagro is new media. If she's still not moving further in her career, Rush. She was crying the other day about her mom being on the Hot 97 shortlist. Exactly. But then shout out to Crazy Files. She posted a whole response saying, well, let me not congratulate you. Let me not do this, that, and third. Bitch, you wanted to be on the fucking list. Just say that shit. Just say it's okay. There's plenty of things I think I'm qualified for. But also don't go off about it either. But that's because I have coping skills. That's because I recognize that your work only speaks so much, but it's about your integrity. And Claudia Jordan was right. She was not on the list because of her own behavior. And like I said before, do you honestly think Hot 97 or anybody in media, let alone any industry, will hire somebody who put out a sexually altered video, got found guilty, and has to pay $59,000? Really, I I just want everybody to think. I want mob radio to think about this, right? Because here's the thing: she's on station head, where there's no FCC regulation. Do y'all not know mob radio? If y'all supported her on Hot 97, WBLS, or wherever fucking radio stations out there, I'm not saying fucking radio stations, disrespect radio. I come from the world radio, but follow what I'm saying. Y'all remember how Wendy Williams got rolled up on by Total because of what she said? Now imagine if she was on a radio station. And let me tell you, the FCC don't give a flying fuck shit or damn what station you on. If it's controlled by the FCC, when it comes to AM and FM airways, radio airways, they will handle you. You can't cuss on FM radio, nor AM. You have to pay a fine. Steve Harvey had to pay $1.5 million for cussing on his nationally syndicated radio show. He talked about on Sway in the Morning. So now imagine if she went live on the radio, even though one person said nobody listens to the radio. Child. Charlamagne just signed a $200 million deal. Ryan Seacrest, Big Boy, everybody in between. So, sweetheart, whoever, whatever, you say nobody listens to the radio, but yet iHeartMedia is still here. Radio 1 is still here. Westwood 1 is still here. Compass Radio Networks is still here. Super Radio is still here. That's the platform that broadcasted Ebro in the morning. ABC Radio, CBS Radio back in the day. Now it's called Audacity. This is what I mean by be about your business. I listed all that shit off. I ain't got no notes in front of me. That's because this is what the fuck I do. Okay? And yes, that is the government, gorgeous. Now, let me land the plane. Let's just say she said all this shit live on air, right? Right? She's in Houston, Texas, right? So let's just say that she was the K104 morning radio show personality. Now, let's look up K104 and see who they're owned by, okay? Okay, here's K104 right here, right? Right here. Now, I'm not implicating K104, but I just want y'all to follow with where I'm going here. Just want y'all to follow where I'm going here. So the company right here, Service Broadcasting Corporation, they're the owners. Okay, let's look up Service Broadcasting. Website. Okay, they don't have a corporate website. But basically, if Milagro went on to say that shit, then guess what? K104 is implicated. Service Broadcast Corporation is implicated. Not to mention, too, you ready for this shit? Are you ready for this? So anyway, are you ready for this? Compass Media Networks would be implicated because they are in connection to it. So if the Milagro Gramz morning show was syndicated through Compass Media Networks, that is guilty by association. So now, to all the affiliates won't get no harm from this because guess what? The affiliates, they get the station, they get the show clock. They get the show broadcasted live on their station, or if you voice track it, then they'll, send it over email. You download it, and then you upload it into the, rundown. I think it was Digital Jukebox, if I'm not mistaken. Digital Jukebox is like basically a jukebox for radio stations. You can go in, plug in any song. The Hey, you're listening to the Brainly Morning Show right here on the hip hop station, number one for hip hop and R&B. Power 92, Power 92, Power 92 jams. Calls up at 433-0292. Be call number 9. Say the phrase that pays. Power 92 jams, the people station. Those jingles that you hear, that's all done through digital jukeboxes, done through an automated system that DJs have. See, that's the inside track. Okay. So, for mob radio, for one person to say nobody listens to radio, child, it would have been worse on radio for the consequences than what she did on YouTube. But see, when you don't understand the levels to shit, you will be basic with the mindset you have. Okay. So right here, Compass Media Networks would be implicated. Service Broadcasting Corporation would be implicated. K104 would be implicated. All right? Let's keep going. Oh, the inquiry may involve the examination of facts, but the designation is ultimately preserved for the courts. Stating whether a defamation plaintiff is a public figure is a question of law for the court. Not for the jury, but for the court. Not for the jury, but the court. Not for the jury, but the court. C-O-U-R-T. Critically, Florida court describes the analysis itself as court-centric terms to determine limited public figure status. For example, it must determine whether a public controversy exists and whether the plaintiffs played a sufficient central role. That is, while the process may require evaluating the record, it is the court's job to bestow the legal label public figure versus private figure. Likewise, courts have framed the media defendant question in court-centric terms, applying clear legal standards to determine whether a defendant should be classified as such. In defining the term media defendant, courts have considered, or the courts have interpreted the statute of the medium language to be limited to news media defendants who publish the statements via another medium. But let's go back for a minute. Okay, let's go back. This is very important. Right here. Indeed, the purpose of Florida Statute 770.01 is to afford newspapers and periodicals an opportunity to make full retraction in order to correct inadvertent errors or mitigate damages, as well as to save the expense of answering to an unfound suit for libel. It says newspapers and periodicals. So because Milagro doesn't fall under that, it is what it is with you. In the words of UNICEF, a mind is a terrible thing to waste, but a wonderful thing to invest in. Relatedly, courts routinely decide whether a defendant is a media defendant as a matter of law at both the motion to dismiss and summary judgment stages of a case. Denying motion to dismiss and finding defendants did not qualify as media defendants. Denying motion to dismiss and finding defendants did not qualify as media defendants. Denying motion to dismiss and finding defendants did not qualify as media defendants. Denying petition for writ of censure after trial court found defendants were not media defendants. Denying petition for writ of censure after trial court found defendants were not media defendants. Denying petition for writ of censure after trial court found defendants were not media defendants. Reversing trial court's finding on motion to dismiss / summary judgment that the defendant was a media defendant. Courts routinely frame the Florida Statute 770.01 applicability inquiry as a legal question, describing the issue posed by the petition for writ censure as the legal question, as whether commoners fell within the statute pre-suit notice protection. Here too, the court determined as a matter of law, the defendant was not a media defendant at the motion to dismiss stage. Here too, the court determined as a matter of law that defendant was not a media defendant at the motion to dismiss stage. Here too, the court determined as a matter of law that the defendant was not a media defendant at the motion to dismiss stage. So because they determined that she was not a media defendant, then that media defendant finding, right, by the jury is null and void, right? But here's the thing, it was only supposed to be an advisement. So when the judge did what she did, everything back then determined that Milagro was not a media defendant. That makes the judge's ruling null and void. My Lord. We're on what, page 1420? We're almost there. We're almost there. Public figure statuses allow constitutional fault burdens, whether actual malice applies. The case what must be proven to oppose liability. So the court describes the status designation to ensure uniform, legal, correct application. Similarly, media defendant status allows statutory protections and operates as a dispositive condition precedent. So the court likewise decides the status designation to ensure uniform, legal, correct application for the statute 770.01. Collecting cases and describing how courts construe the statute's application to a news media defendant. In other words, both labels are status determinations with major legal consequences, but they may depend on underlying facts, but the ultimate classification is the court's responsibility. Not the juries. Thus, while the court may arguably submit narrow factual questions about predicate facts to the jury, which plaintiff contends was erroneous, nonetheless, under the law of the case doctrine, the ultimate legal determination whether defendant is a media defendant for Florida Statute 770.01 for purposes remains for the court to decide as a matter of law. The ultimate legal determination whether defendant is a media defendant for Florida Statute 770.01 purposes remains for the court to decide as a matter of law. Say that one more time. The ultimate legal determination whether defendant is a media defendant for Florida Statute 770.01 purposes remains for the court to decide as a matter of law. For the court to decide. A special interrogatory asking the jury this ultimate status determination improperly transferred the court's gatekeeper role to the jury. Moreover, the pre-suit notice required under Florida Statute 770.01, even applicable, is prerequisite to suit. It is a threshold question that must be resolved before the case proceeds. It is not an issue to be tried after parties have fully litigated the merits of the trial. Accordingly, the court should treat the media defendant interrogatory answer together with the other related special interrogatories as immaterial and or strike them. I'm going to read this part right here. It is a threshold question that must be resolved before the case proceeds. It is not an issue to be tried after parties have fully litigated the merits of the trial. It is a threshold question that must be resolved before the case proceeds. It is not an issue to be tried after the parties have fully litigated the merits of the trial. So, like I said before, because of what happened during the pre-trial, everything else, that basically means, everybody, that this is not the case. That what happened is a lie. It's a lie. It's a cheat. And we don't want it. We don't want it no more. But here's the thing. If Milagro was found as a media defendant, then guess what? Everything is null and void. But because it was determined by the court through the pre-trial, everything else, that she was not a media defendant, then that should still stand to this day, is basically what this section of the document is saying. And don't worry, y'all. I know we got the jumper crawl coming up, so don't worry. I've done this for over 1,000 shows, child. Okay, so listen. Defendant is not a media defendant. The jury found that the defendant, despite advocating for a particular client or personal interest and acting primarily to promote her own business products and services, should be treated as media defendant, ECF number 226 at 23, but no court has ever extended media defendant status to a defendant who supplies and receives information to affect criminal proceedings while maintaining a paid and intimate relationship with the accused. This court should not be the first. I'm going to say that sentence 2 more times. But no court has ever extended media defendant status to a defendant who supplies and receives information to affect criminal proceedings while maintaining a paid and intimate relationship with the accused. This court should not be the first. But no court has ever extended media defendant status to a defendant who supplies and receives information to affect criminal proceedings while maintaining a paid and intimate relationship with the accused. This court should not be the first. Florida's pre-suit notice statute applies to members of the media that seek to inform and initiate unebriated, robust, and wide open debate on public issues. I know. Some people don't like facts. I know. Let me read that 2 more times. Florida's pre-suit notice statute applies to members of the media that seek to inform and to initiate uninhibited, robust, and wide open debate on public issues. Florida's pre-suit notice statute applies to members of the media that seek to inform and to initiate uninhibited, robust, and wide open debate on public issues. So because Milagro did not inform and initiate uninhibited, robust, and wide open debate on public issues, because it was a closed-minded, very narrow and limited debate, that's why she didn't get a notice. Pre-suit, which means before the case, before the trial, before the suit. So if she would have done what she needed to do before this happened, then she would have this pre-suit notice statute applied to her. But because she did not do what she was supposed to do, and she provided a closed-minded, narrow, and limited debate, because she provided a closed-minded, narrow, and limited debate on this public issue, she fucked up. My Lord Jesus. The test is one of function, not form, rather. For instance, operating a blog commercially does not automatically confer media status. But she knew media, though. The mob rail supporter. But everybody else who found the bandwagon, they're the smart ones. Wait a minute, let me read that 2 more times. For instance, operating a blog commercially does not automatically confer media status. For instance, operating a blog commercially does not automatically confer media status. Denying protection where a blog did not operate to further the free dissemination of information or disinterested and neutral commentary or editorializing as to the matters of public interest. And although editorials can receive media defendant protections, such protections are only conferred only to those who editorialize as to matters of public interest without being commissioned to do so by their clients. Let me read that 2 more times. Although editorials can receive media defendant protections, such protections are confined only to those who editorialize as to matters of public interest without being commissioned to do so by their clients. Although editorials can receive media defendant protections, such protections are only confined or conferred conferred or confined only to those that editorialize as to matters of public interest without being commissioned to do so by their clients. So, now I'm covering this right now because I genuinely want to, and because this is a public story, and because Megan Thee Stallion did not pay me, I have protection. So if Milagro Gramz, Bob Rail, or her cult supporters, and you know what? Let me stop because you have the right to do what you want to do, right? But if you are for a black woman going after a black woman when that could be you, you do have problems with yourself. We're not negotiating on that. So because I'm doing what I'm supposed to do, I have protection. So Milagro wants to say, "Oh, Braylon, he dragged me, this, that, and the third." Oh. I read everything off of this motion. That is why it is important for you to bring it up. So that way, if it so happens that you are in that predicament, all they got to do is go to the transcript and the timeline, and they could read the whole thing. They'll be like, okay, he gave commentary, more commentary, let's look at his bank records. I do not see a payment for Megan Thee Stallion, or from Megan Thee Stallion, rather. Therefore, the suit is thrown out. Oh, my Lord. Courts have consistently refused to extend media defendant status to parties who disseminate information on behalf of clients or for personal financial gain. In Ortega-Trello, the court held that a public relations firm registered as an agent of a foreign bank did not qualify as a media defendant, despite having sent press releases to major South Florida media outlets. See, this public relations firm was registered as an agent of a foreign bank. It wasn't registered under the business that they were supposed to be of. Now, if you have, let's just say Brainley's virtual tour is a part of ABC, right? That's the Walt Disney Company. That's under media, right? But if Brainley's virtual tour was under, let's just say Target, then Target is not considered media. Now, you can do a loophole of like, well, Target does promote on television and radio and podcasts and billboards and magazines and this, that, and the third, but that is a utility to distribute information. That does not make Target a media company. In the words of DJ Khaled, congratulations, you played yourself. As the court found in that case, false, intentionally misleading, or defamatory publications have no essential part of any exposition of ideas and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and mortality. Here, defendant statements clearly do not benefit order or mortality. They said, bitch, your existence, your mouth, and your movement does not matter to the order of life, the mortality of life, or the humanity of how we live. Oh my God. Oh my God. Let me say it 2 more times. They basically say what you say, how you move, and who you are does not benefit to the order of life, the mortality of how everybody sees you, and the humanity of how we live. How you move, how you think, and how you are as a person does not matter to order, mortality, or humanity. They said you are a piece of sperm that came out of your, how can I put this? You are a piece of sperm that formed in your mother's womb and came out your mother's vagina. That's basically what they say. Yeah, I'm adding some sauce to it, but that's basically what they're saying. In fact, the jury found unequivocally that the statements were defamatory, thus outside the ambit of protected speech under the First Amendment. Let me say that 2 more times. In fact, the jury found unequivocally that the statements were defamatory, thus outside the ambit of protected speech under the First Amendment. In fact, the jury found unequivocally. That means everybody agreed. Unanimous. All yeses. That the statements were defamatory, thus outside the ambit of protected speech under the First Amendment. CECF number 226, questions 1 and 2. Defendants' defamatory statements not only came at the great expense of plaintiffs' emotional well-being and professional and personal relations, but also by their very defamatory nature caused harm to the public. The deleterious impact of her words is all the more evident here, where defendant's statements sought to imitate a key witness and crime victim and obstructed criminal legal proceedings. Likewise, defendant's use of disclaimers to inform her viewers that she should not be relied on fact reporting cuts against her receiving media defendant protections. You know, I want to go back to something real quick. If you don't mind, everybody. I want to go back to this for 1 minute. What did I say yesterday? Your gift can be a blessing or a curse. Your gift can be a blessing or a curse. Your gift can be a blessing or a curse. Now, these 2 thumbnails have no correlation to each other, but follow with where I'm going here. Right here. Well, in the Bible, life and death is in the power of the tongue, and Megan Thee Stallion wants that tongue dead. Well, in the Bible, life and death is in the power of the tongue, and Megan Thee Stallion wants that tongue dead. Well, in the Bible, life and death is in the power of the tongue, and Megan Thee Stallion wants that tongue dead. Your gift can be a blessing or a curse. Listen, I just drink my water, mind my black-owned business, and I go on to it. Okay. Let me read that 2 more times. Likewise, defendant's use of disclaimers to inform her viewers that she should not be relied on for fact reporting cuts against her receiving media defendant protections. Likewise, defendant's use of disclaimers to inform her viewers that she should not be relied on for fact-based reporting cuts against her receiving media defendant protections. In Tektronix Industries Company versus Vanilla, September 19th, 2025, the court applied these principles to deny media defendant status to a short seller who published research reports accused a publicly traded company that he had shorted of accounting manipulation and fraud. The court held Vanilla was not entitled to pre-suit notice because his admission of bias and self-interest was sufficient to place his statements outside the ambit of free dissemination of information or disinterested neutral commentary. Let me read that 2 more times for everybody. Okay. The court held Vanilla was not entitled to pre-suit notice because his admission of bias and self-interest was sufficient to place his statements outside the ambit of free dissemination of information or disinterested and neutral commentary. 1 more time. The court held Vanilla was not entitled to pre-suit notice because his admission of bias and self-interest was sufficient to place his statements outside the ambit of free dissemination of information or distress and neutral commentary. So when Milagro said, hey, Ingrid, welcome in. So when Milagro said that she's not a fucking journalist, she should not be considered a source. I didn't go to school, this, that, and the third. She played herself. She powed her own self mentally. She became strange fruit. virtually, criminally, and legally. Shout out to Lady Day, Billie Holiday. Okay. Child, let's keep going. We're almost there. Manila's own disclaimers prove fatal to his claim of media status. He said, "We are biased and self-interested, and acknowledge he might have non-aligned or even directly opposing incentives from his readers." I'm going to read that 2 more times. He stated, "We are biased and self-interested, and acknowledge he might have non-aligned or even directly opposing incentives. We are biased and self-interested, and acknowledge he might have non-aligned or even directly opposing incentives from his readers." The court emphasized that Florida law focuses on whether the defendant engages in the traditional function of the news media, which is to initiate, inebriate, robust, and wide open debate on public issues, not Barbella's self-proclaimed motivational commentary. The court emphasized that Florida law focuses on whether the defendant engages in the traditional function of the news media, which is to initiate uninhibited, robust, and wide open debate on public issues, not Brown's self-proclaimed motivated commentary. The court emphasized that Florida law focuses on whether the defendant engages in the traditional function of the news media, which is to initiate an uninhibited, robust, and wide open debate on public issues, not Manila's self-proclaimed motivated commentary. So, Megan's team said, "You know what? Obviously, you're not a journalist because you said so. Number 2, you have showcased a pattern of behavior that determines that you're not a journalist." And then on top of that, they went to the Florida law book and said, "Bitch, hoe, prostitute of social media. This has been here the whole time." Oh, my Lord. Defendant falls squarely within the category of non-media defendants identified in Ortega, Trullo, and Tektronic financially motivated advocacy, like the public relations firm in Ortega Trullo that was commissioned by its client to disseminate information. Defendant admitted that she was paid by Mr. Peace's father, receiving $3,000 over 17 months for promotional services, and sought exclusive interviews that would change her life. Media does not get paid by the person directly in the story. Now, I will say media does pursue interviews, right? They do. Content creators pursue interviews, journalists pursue interviews, experts of different industries pursue interviews. That's like, oh my God, what is that? The guy who made the wallpaper app, that guy. Let's just say, he's a tech expert, right? Let's say that tech expert is going for an interview after somebody at Microsoft. He's got the right to do that, but Microsoft is not going to pay him for an interview. No, because guess what? If Microsoft paid that brother for the interview, then guess what? He will have to follow the questions that Microsoft says, which breaks the code of conduct of being impartial, non-biased, and being purposeful in the truth of your pursuit. She promised to keep conversation with Sunstar Peterson confidential, saying, "I appreciate you so much and will without doubt keep my lips sealed." Trial Exhibit J48, defendant September 2020, Instagram direct message with Sunstar Milagro Cooper. Trial 11/10 through 11, November 18th, 2025. Her content was neither disinterested nor neutral. She acknowledged that Sunstar referenced me as a dart and confirmed receiving travel accommodations for meetings with him in Miami. November 17th, 2025. On the other hand, defendant claims to have never contacted plaintiff in an effort to conduct due diligence and a comprehensive investigation into the facts. Defendant admitted that she has never met or contacted the plaintiff. Like Manila in Tektronic, defendant's own words condemned her claim to be a stash. She stated definitively and contemporaneously that her commentary is not meant to be a news report and I shouldn't be regarded as a news source any damn way. She stated definitively and contemporaneously that her commentary is not meant to be a news report and should be regarded as a news source any damn way. She stated definitively and contemporaneously that her commentary is not meant to be a news report and should be regarded as a news source any damn way. Defendant's October 30th, 2024 live stream clips. Defendants supplied information to the producers in an effort to show that Daystar Pizza was innocent, then published information she received from them without any independent cooperation in order to sway public sentiment. Trial Exhibit J19, defendants November 25th, 2022, email to Sunstar Peterson with alleged dirt on the attachments that may be of value. Sunstar's text to defendant that he has breaking news concerning the detective investigating the powing. November 18th, amending to send in Sunstar information to help Daystar's criminal defense, acknowledging she spoke to Sunstar all the time, including the morning she published the false DNA evidence. The jury's verdict confirms that they believe defendant acted on behalf of Mr. Peterson, despite her testimony to the contrary. The jury was instructed that Miss Pete claims that Miss Cooper. Sorry. I've been reading facts, okay? That Miss Cooper acted extremely and outrageously by coordinating with Mr. Daystar Peterson and others to distribute false statements about Miss Pete and to promote and distribute altered sexual depiction of Miss Pete, which caused her severe emotional distress. ECF number 224 at 7. The court similarly instructed the jury that plaintiff sought punitive damages for conduct arising out of that coordination. ID at 10. The jury's verdict in favor of plaintiff on all counts as award of punitive damages is unmistakably a factual finding by the jury of the coordination between defendant and Mr. Peterson. See ECF number 226, and not just in cooperation, but the kind that's so extreme and outrageous that goes beyond all possible bounds of decency and is utterly intolerable for a civilized community. As the record reflects, defendant's so-called reform was nothing more than the public relation arm of the Petersons. Her nearly singular focus was falsely discrediting plaintiff to advance Mr. Peterson's standing in and out of court, and when the defendant was not acting as Mr. Peterson's mouthpiece, she was, as the jury found, inflicting intentional emotional distress and promoting a deep fake pornographic video of plaintiff. CECF number 226. Defendant's conduct is so far ahead of what constitutes as a media defendant that no court has ever granted media defendant status in these circumstances. The court has already ruled twice that defendant is not a media defendant under statute 770.01 and should do so again now. Relief under Rule 59E and Rule 60B6 is appropriate should the court disagree that the jury's verdict on defendant's media status was advisory, because it's the court that decides it. It was an advisory recommendation from the jury. Once again, the court decides the final status for Milagro, not the jury. That was an advisory recommendation from the jury. Once again, the court decides the final judgment, not the jury. That was an advisory recommendation. Oh, Lord Jesus. Such that the December 2nd final judgment, ECF number 227, was also final judgment under count 1, defamation per se. Plaintiff requests relief from a final judgment under Federal RCP 60B6, allowing relief from a final judgment or order for any other reason that justifies relief, and Rule 59E, allowing motion to alter or amend a judgment. The circumstances here are extraordinary. The final judgment rests on a manifest legal error and results in manifest injustice. Not only did the court's final judgment revisit and consider the same legal question it had already decided in the motion to dismiss order. So they're basically saying, y'all decided this shit already, and something, the Kool-Aid ain't sweet. And this is expired Kool-Aid, and y'all are now liable for what y'all produced. But also relied on permit the jury to resolve legal classifications and standards reserved to court. So they basically said, okay, listen, we're going to pretend that this is a, luxury package Cadillac Escalade, even though it's really a basic one. My Lord. And for those of you who are wondering what I mean by that, basically, or let me flip reverse, rewind it back. Let's just say, right, that you have a premium Escalade, right? But you sell it for like $50,000. That is basically defrauding the customer, because the premium package should be at the price of what the premium package is supposed to be. But because you took that premium Escalade with the premium features and reduced it to $50,000, you are doing false advertisement. This appears to be the first case of its kind. Hang on, y'all. Hang on, I'm gonna have to switch the time up. Hey, Merry Christmas to you. I hope all is good with you. By the way, I hope that Winter Wonderland went well. And I hope everything is good with the grandkids and Anthony. So all good in the neighborhood with me and Tea Talk with your girl. I do miss her. I do, I've been working over here. Y'all see, we've been on for 2 hours, 26 minutes, and 33 seconds covering this. And I think Tea Talk with your girl will agree with me on this, because I remember she said on the Silver's channel when I brought Mr. Beast that I cover everything else of the culture more than anybody else in this former sector. And I would like for anybody, Lati or anybody that works at Tea Talk with your girl to come out and say that I'm lying. Okay. All right. Moving on. Yes, indeed. So let me do this here, because I'm going to have to switch it to 9 o'clock. Give me a moment, y'all. Give me a moment. Give me one moment, so please. Because I know we're pushing it against time. And y'all know me. I like to finish out a whole stream. I don't like cheating y'all out of a good time. I don't like doing that shit. So give me one moment. I'm going to upgrade it to 9 o'clock. No, we're still going to do the virtual. We're still going to do the virtual tour jumper and crawl. I cannot wait for y'all to see that. That's going to be so good, so good. Switch that to 9, because we're almost done here, y'all. We're almost done. I just don't like cheating y'all out a good time. I don't like doing that to y'all. There we go. Okay. So we're good. It's updated for 9 o'clock. So just give me a little bit of time, because we're almost done here. Let's see here. Let's see here. Let's also relied on and permitted. Oh, yeah, I already read that. This appears to be the first case of its kind in which a jury decided, as a matter of fact, that a defendant's qualification as immediate defendant. This appears to be the first case of its kind in which a jury decided, as a matter of fact, a defendant's qualification as immediate defendant. This appears to be the first case of its kind in which a jury decided, as a matter of fact, a defendant's qualification as immediate defendant. The consequences are substantive, not merely technical. This combination of legal error and outcome determinative effect is exactly what rules 59E and 60B6 are designed to prevent manifest injustice. As such, the court should alter or amend the judgment to reinstate the jury's verdict and enter final judgment consistent with that verdict. In conclusion, wherefore, you know what I thought of when I said that? The B movie. John Goodman, the John Goodman. Ladies and gentlemen of the jury, I present to you an imbecile that needs to be put down in every motherfucking ass way. John Goodman did say that. I'm just sad this is awesome. Let's roll the fuck on. Wherefore, plaintiff respectfully requests that the court disregard or strike the B. Braylon, point. Be serious. Get your head together. Okay, you're live. This is important. Be about the business of being factual in your shit. But you are. That's why you're at now 183,000 total views on the road to that big goal. Anyway, moving on. Wherefore, plaintiff respectfully requests that the court disregard or strike the media defendant interrogatory answers as intermediate, enter final judgment in plaintiff's favor on count 1, defamation per se, consistent with the jury's verdict ruling finding defendant liable and entering such other relief the court deems just and proper. And ladies and gentlemen, that is everything right here. I hereby certify that on December 23rd, child, not the day before Christmas Eve. Ho, 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 Merry Christmas to you. Were you naughty or nice? A true and correct copy of the foregoing was served via electronic mail or email on the following: Jeremy McLick, Esquire, Ace, Aselli, A, law firm, PA, 33 Southwest 2nd Avenue, Suite 1100, Miami, Florida 33130, 786-420-3014. JeremyAstelllaw.com and Natasha Ben Ami, Esquire Ben Ami Law Firm, PPLC. This is Milagro's team right here. This is Megan's team right here. Okay. Ben Ami Law Firm, PLLC, 14681 Biscayne Boulevard, 102. That's their suite number, I think. North Miami Beach, Florida, rather, 33181, 954-686-2446. Natasha, BenMeLaw.com. And that is every motherfucking document. You know what? I'm going to applaud myself real quick, if you don't mind, ladies and gentlemen. I'm going to applaud myself real quick. Yeah. 20 pages. Live. Okay, just live. All the commentary in between off the top of the book. And did I mention that this is a actual factual smacktual document? So, I think that Milagro and Mob Ray on her supporters and this, that, and the third, they should really watch this live. And they should get a game plan. They should be making moves right now. But remember. Let's go back to it. Let's go back to it right here. Let's go back to it. Right here. Let's go back to it. Response due by January 6th, 2026. Now, with that being said, where the fuck is it? Look at bird. Oh, here it is right here. Yes, generally failing to respond to a lawsuit's initial complaint or critical court motions, which this was a motion, can lead to a default judgment. Generally failing to respond to a lawsuit's initial complaint or critical court motions can lead to a default judgment. Yes, generally failing to respond to a lawsuit's initial complaint or critical court motions can lead to a default judgment. So, if January 7th happens, right? And this is how petty I would be. You got until 12 a.m. January 7th of 2026. If it's 12 midnight on January 7th, 2026, defamation is back in. And you don't have the right to disregard it because you did not respond. Let's see how many days is that. You got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 days to respond. Child. That being said, I'm going to turn my camera now because we've done the whole show for over 2 hours. Yes, we have. Woo, child. Excuse me. Talk about show. Talk about a show. Well, Braylon is sounding mighty good, ain't he? Yes, indeed. Oh my God, child, why? Okay. There's always something going on in these damn streets. We'll talk about Tyler Perry soon, y'all. Okay, listen. I just got done reading 20 pages live. Okay, so respectfully and disrespectfully, at 9 o'clock, we're resting with our jumper crawl, which I cannot wait for y'all to see how that's going to work. I'm very excited about it. I talked to my mom about it on Christmas Day yesterday, and I've been debating on this format. I didn't know how to do it because, like I said, Divine Virtuous Woman asked me if we could, travel to different places, like, Italy and France and Germany and places like that. Then I think Erica 70 also asked as well. And so I was racking my brain, and I think I found a way to do it. But y'all will find out what that is now at 9 o'clock. So, yes, indeed. So we're going to play our anthem real quick here so I can rest my voice for a little bit. And we'll be back with more on Brainley's Virtual Tour Live after this. We are live on tour. Like, comment, share, subscribe. We'll be back right after this. Roll it.
Lights go low, the city goes high. Stories untold under moonlit skies. Braille only got the vibe, got the flow for the culture. Yeah, you already know. Turn it up, lean back, feel the breeze. Late night truths drifting through the trees. It's for the culture, by the culture. Braylon's got the soul to show ya. Breaking it down, lifting it higher. Feel the rhythm, spark the fire. Headlines flip with a soulful twist. Behind the scenes where the magic sits. It's the heartbeat of the now and the then, where the story starts and never ends. Tune in, lean and feel the groove. Every moment, a vibe you can't lose. It's for the culture, by the culture. Braylon's got the soul to show ya. Breaking it down, lifting it higher. Feel the rhythm, spark the fire. Hear the whispers in the city's hum. Echoes of stories where we're from. A beat, a step, a voice so clear. The pulse of us, it's all right here. We got soul, we got rhythm flow. Spotlight shining, we in the zone. This is the place where the culture's grown. Stories untold, now they're coming alive. Braylon Lee got the vibe tonight. One thing to know and two things for sure. Higher is waiting and lower is available. But either way, we gotta go on tour. It's Braylon Lee's virtual tour, where the culture makes its move. Feel the love, feel the truth. This is us, this is you. From the unknown, the unembraced, and more. This show, this brand, and the possibilities of what can be is all here for you. I'm just a kid from the rock, trying to be a rock for people, trying to make it best they can to become. Being moved is a creator of power to lift up all of us, not just a selective few. For the culture, by the culture, here we be. Braylon Lee, bringing life to your screen. Feel the soul, feel the truth. We're free, trust and believe. It's entertainment, news done our way with Braylon Lee. Spotlight sharp like a diamond shine. We see the stars, but the stories align. Deep in the soul where the heartbeats find. The pulse of the people redefining time. Just a pro tip, people have to earn the right to hear your story, but in addition to that, people have to earn the responsibility to be a part of it. Just because we are not seen by everybody doesn't mean we are not been seen by who needs to see us. Noise equals attention and sound equals purpose. Anybody can be a creator, but it takes a somebody to be an artist.
I gotta tell you, that anthem still gets to me every motherfucking damn time I play it. If you like that anthem, you can go to our video tab and listen to that anytime you want to. Absolutely right there. We came up with that anthem because the channel is evolving, it is growing, it is centering more and more into place of what this platform needs to be, and so we need an anthem that matched, and does match it, and has that energy to showcase how we stomp the yard, ladies and gentlemen. Yes, indeed. So, yes. So, well, y'all, like I said, they, Milagro's team. I don't know if she has a team or not. This child can't pay people. You ain't got no team. But anyway, with that being said, we'll see if Milagro's team files anything. I think because now this is my honest opinion. I think because Milagro Gramz is negative $10,000 in the hole, right? And y'all know she's got that, new media fundraiser going on. I think that they are probably I think the court rather is probably going to want the $59,000 to be, funded by Milagro Gramz herself, not crowdfunded. You know what I mean? So, best thing you can do, child, is, take this to Lifetime, take this to All Black, make it a limited series, or you can make it a big movie. And, no, actually, you could do that, but I was going to say it depends on if the defamation is back in place. Now, the defamation is back in place in addition to all the legal fees and everything else. Then you're going to have to, stomp the yard and, get your payment, right? And you're probably going to have to put in the contract like, hey, listen, I'm going to have to pay this money. So, yeah. So that's my genuine opinion on everything. I thank each and every single one of you for being here. I hope you had a good time with me this evening. Yes, indeed. So, like I said, we'll stay tuned for that, and we'll talk about Tyler Perry soon. I told y'all the year wasn't over yet, didn't I? Anyway, let's get to the Daily Motivator here, and then we'll head on out. Here we go, everybody. You get paid to impact the world, not be impacted by it. Cool. Let me read this one on camera because I got a feeling it's going to be a good one, child. So, hello, good to see y'all once again. Purposeful ambition. It's time for Nick Motivator. Friday, December 26, 2025. Purposeful ambition. Move forward with ambition. Temper that ambition with humility, gratitude, and kindness. The problem with blind ambition is it makes you blind. Your obsessive desire causes you to lose sight of what it means to be human. Oh, Ralph Morrison, not you talking to Milagro Gramz. Oh, my Lord Jesus. Achievement is necessary. Achievement is necessary. Come on, Brian, get your head in the game. God, get your head in the game. God, get your hand in the game. Woo! Shout out to all the High School Musical people out there. Listen, the achievement is necessary and important, yet it is not everything. Achievement must always be a means to an end, for it is woefully sufficient as an end unto itself. You're able to achieve great things, yet you also have the capacity for love, joy, connection, and so much more. Pursue ambition in a way that makes you more a part of the rich tapestry of life rather than apart from life. Achieve in the service of a purpose that is deep, generous, and more meaningful than the achievement itself. With ambition, you can create value that flows from the genuine, unique person you are. Just make sure the ambition does not consume that beautiful person in the process. Woo, child, let's talk about some purposeful ambition. So, whenever you are being about the business of going after something, you have to make sure that the energy that you are requiring of what you want given to you is the energy you put out. Given shall be given unto you, good measure, press down, shake it together, run over, and then we'll give it to your bosom. That's the first thing. So don't ever be so ambitious that you're not even willing to be ambitious yourself. Don't ask the world to be so ambitious that you're not ambitious yourself. Don't ask for the world to be so ambitious that you're not ambitious yourself. That's the first thing I'll tell you. The second thing I will tell you is you're able to achieve great things, yet you also have the capacity for love, joy, connection, so much more. The only way you will ever have that capacity is if you make a choice. My mom has always said, every decision you make is on you. Sometimes we don't realize that that is a blessing and a curse. Okay, that's the second thing I'll tell you. Finally, third thing I tell you is just make sure the ambition does not consume that beautiful person in the process. I can officially say this, that with everything that I've been through, right? And I'm going to be real with y'all. I do wish there were some things that would have happened a little bit more. I do wish I was a little bit more protected, a little bit more invested in, a little bit more loved on. I will definitely say that. For many things, what I've been through on YouTube and in my life and this, that, and the third around the world, I. But here's the thing. The more you complain about, and here's the thing, it's a difference between complaining and handling your emotions. When you handle your emotions, you are no longer bound to that sentence of that emotionality. When you let yourself go, you are no longer bound to that sense of emotionality. When you let yourself go of whatever you're thinking, you're no longer bound to that sense of emotionality. But when you hold on to what has not been done, you are missing out what God has done. Let me say that on the big screen. When you negate, or not negate, but when you keep holding on to what this person didn't do, that circumstance, all around the world, and let me just say this, I think this goes for everybody. There should have been people, what do they say, person, place, things, ideas, concepts, all those things should have been there for you, for me, and many other people all around the world. Okay? In the same token that is true, you should also not negate what God has done in the meantime, between time, through everything you went through. Even if that is a true fact, it should not negate everything that God has done for you. Because let's keep it a buck. Even though I was in the well and the storm was happening, this, that, and the third, and people did what they wanted to do, God said, I need you to rest mentally, close your eyes, and go the fuck to sleep. I got this shit. And we're at 983,000 total views. Because guess what? You don't let person, place, thing, idea, concept define you. You define you. When you're the operator of your soul, can't nobody tell you about your soul. Because what ends up happening is they look like the fucking liar and you look like the fucking truther. Shout out to Josh Peck. So with that being said, everybody, it is time for the best outro on YouTube. Know what you do and do what you know. Never say you want one special, because you are always one of us in trust. You may not be where you want to be, but by the end of it, you'll be where you need to be. Do what you've been chosen to do. Wise one thing, call yourself, another thing be chosen. One love, much love, all love. I have spent time with you. You have spent time with me, and hopefully by spending time together, Ross will be great together. And always remember where you're doing radio, television, YouTube, living your best life, or just recognizing that, hey, listen, you can be mad. You can be pissed. You can be whatever you want to be in your feelings about. But once you get out those feelings, recognize that there's a finish line and to keep going. Make sure the replay is not just worth for you watch it, not just worth for you listen to it, but for you want to experience it again. I love you. I value. I embrace you all. Always remember, see love you gotta give it, or see love you gotta give it, or see love you gotta give it. Wherever obstacles you've overcome, where success you have achieved about this particular day, I'm extremely proud of you, but no one else is proud of you. Proud of your damn self. And finally, y'all listen. Just because somebody is at peace, at rest, and at comfort with who they are, don't mean they don't still feel some type of way about how they should have been protected, this, that, and the fucking third. What they've come to recognize is, I can feel the way I feel, but I'll also know that higher is waiting for me, lower is available, but either way, I have an opportunity to go out on tour and be something of myself. Sounds like somebody on the, oh wait, that's me. Commercial break and fireworks are coming your way. For the day that was, for the day that's coming, for the blessings on the way for you, me, all of us, as a society, as a people, as a culture. I feel love and I send it right back to you. By the way, if this is your final tour for the evening, good evening to you. There's plenty of content creators out here doing some great stuff. Just be careful where you go, because not everybody appreciates quality. Some people rather have quantity to look like there's somebody when really they're nobody. Listen, if that ain't for you, don't pick that fucking bullet up, okay? But with that being said, I will see the rest of you 7 minutes and 8 seconds for our virtual tour jump across. I can't wait for y'all to see this format. I love you. I value. I embrace y'all. I feel the love and send it right back to you. Bye, everybody. Oh, sorry. There it is. There it is. Now we have 6 minutes and 50 seconds right there. I'll see y'all right there. All right. Love y'all. Good job, Ray. Good damn job. Good motherfucking ass job. Bye, y'all.
I thought I should tell you they've been talking about you. Yeah, they've been talking about you. They've been talking about the fact that they've done everything they could to stop you and everything they could to block you, but you still win. They've been talking about the fact that they have undermined your success and they have tried to sabotage your seasons, but you keep winning. They've been talking about the fact that even though they don't like each other, they get together to try to kill you, but you keep winning. They've been talking about the fact that you were voted least likely to succeed, but like cream, you keep rising to the top. They've been talking about how they tried to burn your world down, but like the phoenix, you rose from the ashes. They've been talking about you. And you know what they say? Oh, she's just lucky. He's just lucky. But no, you ain't lucky. You're anointed. You got something on you. You got favor on you. You got power on you. You were born to win. Now, they can call it luck, but it's grace. They can call it luck, but it's favor. But whatever they call it, it doesn't matter, because you know what God calls you? Do you know what God calls you? A winner. I thought I should tell you, they've been talking about you. Yeah, they've been talking about you. They've been talking about the fact that they've done everything they could to stop you and everything they could to block you, but you still win. They've been talking about the fact that they have undermined your success and they have tried to sabotage your seasons, but you keep winning. They've been talking about the fact that even though they don't like each other, they get together to try to kill you, but you keep winning. They've been talking about the fact that you were voted least likely to succeed, but like cream, you keep rising to the top. They've been talking about how they tried to burn your world down, but like the phoenix, you rose from the ashes. They've been talking about you. And you know what they say? Oh, she's just lucky. He's just lucky. But no, you ain't lucky. You're anointed. You got something on you. You got favor on you. You got power on you. You were born to win. Now, they can call it luck, but it's grace. They can call it luck, but it's favor. But whatever they call it, it doesn't matter, because you know what God calls you? Do you know what God calls you? A winner. I thought I should
Prepare for a journey beyond imagination, beyond belief, beyond anything you've experienced before. Universal Epic Universe, a new theme park where you'll step through extraordinary portals to 5 immersive worlds. Prepare for a cosmic voyage of discovery, an isle of fire-breathing excitement, a shadowy world of monsters and mystery, new wonders in the wizarding world, and a new way to play. Plus the splendor of a magnificent resort hotel overlooking the park. It's all new excitement at Universal Orlando Resort. A week's worth of vacation thrills with 4 amazing theme parks, a variety of spectacular themed hotels, and incredible dining and entertainment. It's all at Universal Orlando Resort, where you'll find new adventures every day. Explore the astonishing worlds of Universal Epic Universe at Universal Orlando Resort.
Because here's the thing, a good streamer can find other content. Because here's the thing, a good streamer can find other content. Because here's the thing, a good streamer can find other content. Because
Child relevant over there doing his thing, minding his GD business, staying out of trouble, trying to get the folks some positive stuff to talk about. Besides lying all the damn time. Child relevant over there doing his thing, minding his GD business, staying out of trouble, trying to get the folks some positive stuff to talk about. Besides lying all the damn time. Child relevant over there doing his thing, minding his GD business, staying out of trouble, trying to get the folks some positive stuff to talk about. Besides lying all the damn time. Child relevant over there doing his thing, minding his GD business, staying out of trouble, trying to get the folks some positive stuff to talk about. Besides lying all the damn time.